Yes, madam.
My lord, I want to mention item number 31.
31.
Yes. I have been appointed as legal aid counsel for the respondents, but I have not received a paper book.
Uh,
I have taken consent from
MS J. Doji, London, Legal Aid Council. Submits that she has not been furnished with the paper book in this matter. Item 31. Therefore, she prays that matter may be listed after furnishing of the registry may be directed to furnish the paper book. Mr. Arson Leonard, counsel for the appellant is present. Next paragraph. Considering the above, registry to furnish the paper book and list after 3 weeks. 3 weeks. List the matter after 3 weeks.
Number 5, announcement of title.
Okay. Yes. Writ petition dismissed.
May I, Lord, sir?
Yes.
I'd like to mention item number 30.
13.
30. On the behalf of you, Deka, petitioner.
On the prayer of so and so, London Council for the London Council appearing for Mr. U. Decker. List this matter after 4 weeks. 4 weeks.
Okay. Much obliged.
Yeah, madam. I think to mention item number 4.
4.
Yes, ma'am. I'm for the petition.
Yes.
Nothing comes in.
Yes, nothing. We have fixed it for disposal today.
Moreover, my lord, it is reflected in the letter of extension.
Doesn't matter. Where he is?
Out of station, my lord.
When he is coming back?
After 1 week.
Let him ask him to come back on Friday.
Actually, my lord, we out of station for some.
We'll fix this matter on Friday.
My lord,
No,
after
these
1
cases should not be allowed to just keep it pending. It's all unnecessary.
after 1 week.
And in that case, we will fix after 3 weeks. Giving the fixed date. MS so and so learned counsel appearing on behalf of Mr. T. Sunit, learned counsel for the petitioner. Submits that Mr. T. Sunit, learned counsel is out of station, for which he prays for listing the matter, for which he prays for adjournment of the matter. Considering the submission of the learned counsel for the petitioner, list this matter on 03/09/2024. Will it be auspicious for you? 03 0309/2024.
Mayor Rasif, I'd like to mention item number 7
7.
on behalf of Y Pangu.
Huh?
Y Pangu.
Y Pangu? Item 7.
Yes.
Y Pangu is not there.
Y Pangu instruct me, take adjournment for 4 weeks.
Who is Y Pangu?
Leading counsel of respondent number 2.
Respondent number
2.
2 in item 7.
Yes.
Mr. So and so learned counsel for the learned counsel appearing for Mr. Y Pangu. Learned leading counsel for the respondent number 2. What was it? Submits that. That means that learned leading counsel for respondent number 2 is indisposed today for his praise for listing the matter after 2 weeks.
Lordship 4 weeks.
4 weeks.
Public.
Praise the Lord, this after 4 weeks.
May your lordship, I beg to state, item number 8 on behalf of Tang.
Okay. On the prayer of Mr. T. Tang, the prayer being made on behalf of Mr. T. Tang, learned counsel for listing the for adjournment of the matter. Let the matter be listed after 4 weeks.
After 4 weeks,
When do you want?
after 2 weeks,
2 weeks.
much obliged.
Yes.
Item number 6.
Wait for that.
Can side please.
Wait. But my name is not reflected, but I find the offer.
6.
6.
Yes.
We're challenging basically 2 orders passed by the first by the London CJ my lord 5/11/2021 and the first appellate order by the London District and Session Judge dated 5/8/2024.
Where it is?
Wherein the my lord petitioner number 2, who is a lady, has been directed to be removed from the shared household. Now, before your
No, where is that?
the first order is at
27.
174.
5, 8 or 5?
This is
Which
the
one?
first order.
5, 8, 2024.
5/11/2021.
Where it is?
174.
174.
174.
174.
Before that, my lord, can I take your lordship through 2 provisions of the Domestic Violence Act?
We'll see first this.
Because this, in my humble understanding,
Yes.
section 2F
Ah.
has been wrongly interpreted.
Hmm.
And the judgment in Indra Sharma and VKB Sharma
Hmm.
has also been wrongly interpreted.
Where is
Petitioner number 1. Petitioner number 2, my lord, is the second wife of the petitioner number 1. Now, your lordship will kindly have page 178. These are the relevant portions.
Page 83.
It starts from 178, the grounds on which the removal order has been passed.
Hmm.
178. If
Yes,
you're
just come to page 183.
180,
83. Last. According
yes,
date.
yes. In view of the discussion made above, this court is the considered view that as an interim, respondent number 2 is liable to be removed from the shared house, i.e. residence located at Pakam to accord as well as directly vacate from the shared house within a period of 1 month from today. The respondent number 1 shall take suitable alternative accommodation for respondent number 2. The aggrieved person and respondent number 2 shall look after the aged grandmother of respondent number 1.
Hmm.
This order could not have been passed in terms of section 19 of the DB Act.
It's okay. She'll not be removed. But you petition number 1, you arrange the accommodation.
There is another thing, my lord. How
It's
can
it's your responsibility.
it is my responsibility, but how can the largest citizen pass an order for removal contrary to the statute when there is a protection granted therein?
Then you file an appeal against this.
Yes, we filed an appeal against this.
Then
It's a longish judgment. Starts from
27.
27. Because the basis on which these findings have been arrived at
Yes.
are basically three grounds. That there was a family meeting. That in the event I marry the petitioner number 2, that I will not bring her into my house.
Practically
There
correct.
is something, my lord, she will have to go to a civil court to have it enforced. Second ground, in terms of the CCS rules, since I did not take any permission to marry the second wife, my marriage is void with great respect. But how can the declaration be made? If, my lord, I have not followed the CCS rules, I being a government servant, I am entitled to, my lord, it's a departmental proceeding. That is for the department to do. But how can they issue this removal order, my lord, pass this removal order in, my lord, violation of the act? Because 2F has been totally wrongly interpreted. It's a very longish judgment. Directions is the same, page 60. But these are the grounds on the basis of which they have come, especially the appellate court, relying upon 2F has said that I am not a woman, my lord. 2F is for the purpose of, my lord, those women who comes under 2F, they will be entitled for protection under the act. It is for that purpose. In any case, my lord, the respondent is not even staying there anymore. She is in Itanagar now. How can, my lord, the London trial court in the first appellate court pass an order beyond the statute, my lord? My lord knows.
It's a revision.
It's a revision.
Then we'll stay this and for the interest of the parties,
My lord.
since we'll be staying this, we'll direct the petition number 2.
Petitioner number.
Petition number 2
My lord.
to stay in the present accommodation, not in the house.
My lord.
Because if we directly stay this,
Yes.
this will create a problem.
My lord,
Between them.
that is another thing, my lord. But how, my lord,
No,
beyond the
law
statute that order
cannot be
passed?
law cannot be so blind that we shut our eyes the practical.
That I understand,
realities.
my lord, but there is a bar under the statute.
Well, that's why
And I am making a statement, my
privacy
lord.
will stay this,
My lord.
but we'll further direct because the interim order is passed in her absence. Respond number 2, 1.
Yes,
We'll direct till the next returnable date. We'll stay
yes,
the impure orders,
my lord.
but then we'll direct you to the petitioner number 2 to be here or somewhere else, or arrange the accommodation till returnable date.
I should be out,
Since-
out of the house.
Yes, for a time being.
My lord,
Since you are saying that you are staying in the Itanagar,
no.
not in the
Respondent is staying in Tanagar, the first one. Yes. She has developed some psychiatric problems and she is under treatment here.
These all because of these only, because of you only.
My lord, that may be, my lord. How can I get into all this, my lord?
No, it's bound to happen. Let us go beyond the letter of
My
the law.
lord, fact remains. There
Let
is
us
no
go
bar.
beyond the letter of the law.
I am not the only one that has a second wife.
Doesn't matter.
But my lord, ultimately the issue when
That's the problem. Those having a second, those having a second wife,
Yes.
they must be managing it.
That's
But
another
you-
thing, my
because
lord.
because your
Ultimately, but
second
the
wife,
issue- but
your
the
first
issue-
wife has to develop a psychiatric problem. This is something.
2012 से
Oh, no, my instruction is that is from 2012. Maybe because of the P1 my lord got married. I'm not on that, my lord.
Yes.
But ultimately, the test is whether these two judgments, orders, interim orders, are in consonance with the act or not. appellate judgment order, my lord, is totally misconceived. Totally misconceived. Indra Sharma and VKB Sharma had been totally misunderstood. And 19, my lord, kindly have section 19 for a moment, my lord.
DB.
Domestic
Domestic violence.
DBA.
Intention is crystal clear.
Section 19.
19. 19. Residence orders.
Yes.
My lord, kindly have directly B, 19B.
Hmm.
These are the orders that can be passed. Directing the respondent to remove himself from the shared household.
Hmm.
The word uses himself. Does not say respondent. Why, my lord? The legislature will say that. Then, my lord, will have the proviso. There are other orders that can be passed than the proviso.
Hmm.
Provided that no order under clause B shall be passed against any person who is a woman.
Pending all this litigation,
Right.
unless you make some alternate arrangement, accommodation, either of the two,
Well,
either of the two.
That is something, my lord.
Things may
My lord, that is something,
aggravated.
my lord, as a lawyer, I cannot say, but my learned friend has been dealing with all of them. That is something I will advise him to do that. But my lord,
Yes.
in light of the law, my lord, how can these two orders?
Because particularly,
That
you
I-
may know me also that
that I understand, my
I
lord.
consider the element of
understand.
human thing has to
I
be
will
there.
personally, my lord.
I'm not saying that we
Yes.
don't go by law. Obviously,
I am
law is for the
I have understood your lordship's
benefit
concern.
of the
I
citizen
will
only.
personally request my learned friend, when maybe I will talk to him to do the needful. That is
Yes.
another thing. Because there are other,
See the other treatment.
my lord, there are other interim orders.
She must be staying at eternal because for treatment only.
My lord, all
Respond
this
number.
aspect, if your lordship directs that her accommodation and everything in the interim here, that I should take care of, I will take care. There are other interim orders. Maintenance, I am giving. Protection, no issues. There are 2 buildings, all rents taken by her. I have accepted everything.
But presently she is here.
Yes.
But then normally when the she stays.
She has been shifted since last almost 1 year has been completed. She has been shifted along with all.
She's
her
not staying.
belongings. No.
She's not staying with you. Petition number 1.
No.
Petitioner number 1 is still with
No.
respondent.
Respondent number is not staying
No,
with
no,
the petitioner
no.
number 1.
No.
They're staying separately.
She has been shifted to each other since last 1 year. Along with all her belongings. And now it's ready.
My lord will kindly consider that maintenance amount I am giving, rent from these 2 buildings she is taking, I have agreed to that. There is a family settlement to do. I have accepted. There is no domestic violence. All the other interim orders that have been complied with. These 2 directions are apparently valid.
But the case is pending.
Yes.
It's you are against the interim.
I am only to the extent of this one, removal. The other interim orders I am not challenging. There are other interim orders, these are dated, my lord, 23/9/2021, that is at page 105. And 8/10/2021, page 109, for grant of all these things, whoever giving them. Because the language is clear, ma'am. If your lordship directs in the interim that the care for her here at Itanagar also be taken care of by me, my lord, that is acceptable.
Is she claiming that, yes, is she claiming that she should be allowed to go stay in the house?
No.
Only
She
for
has
removal.
already been given the residential right. But she has been.
Removal is not against to the petitioner number one.
No, petitioner.
He should have been removed. Because only he could have been removed.
Had Mr. Deepang learned counsel for the petitioners. Next paragraph. By filing this revision petition, the petitioners are agreed by the impugn order. Impugn order that is 05/11/2021 passed by the Chief Judicial Magistrate Alo in domestic violence case number 13 of 2021. Whereby by way of an interim order, inter alia, has been directed that it is directed that the petitioner number 2 directed the petitioner number 2 to vacate from the shared house within a period of 1 month from the date of order, and also the order that it 05/08/2024 passed by the district and session judge West Bengal, Alo in criminal appeal number 01 of 2021. While rejecting the criminal appeal against the order dated 05/11/2021 has provided that the petitioner number 1 to arrange alternate accommodation for the petitioner number 2 in any place within a period of 2 months from the date of the order. Next paragraph. Mr. Deepang learned concept referring to the provisions of section 19 of the Protection of Women Domestic Violence Act 2005, particularly 19(1) within bracket, small b within bracket, and it's and the provision submits that the order the impute two orders by the learned magistrate, CJM, Chief Judicial Magistrate, as well as the district and session judge, have been passed in total misinterpretation of the above provision. As the direction can be passed for removal from the shared household, provided that the question sought to be directed to be removed is not a woman. He submits that he further submits that the learned courts below have both the court below have misinterpreted the judgment.
Yes,
What is the judgment?
2013 15 CC 755.
Misinterpreted.
Yes,
Misinterpreted the judgment rendered in the case of, just give the name.
Indra Sharma versus V.K.V. Sharma.
Reported in
2013, 15 SCC, 755.
7.5, and that's all.
Yeah. This was a case.
Therefore, therefore, the impute orders on the face of it is illegal. Issue notice to the issue notice to the respondent. Only one respondent, sole respondent, returnable by 3 weeks. Petitioner to take a stage for service of notice upon respondent number so and so. The rest of the is will be process. Next paragraph. Considering the learned both the learned court below, privacy appears to have was the impute orders on misinterpretation. Should we say misinterpretation or wrong application?
Why don't we say in violation of 19B and its provision?
Privacy in violation of provisions of section 19 so and so of so and so.
The provision.
And having considered the judgment rendered by the Honorable Supreme Court, still returnable that the impute orders so and so about shall remain state list of since the impute order is since the interim order is passed in the absence of the respondent, the respondent is liberty to file application for modification so and so.
And
If so advised. Please, next paragraph. Considering that the
High Court.
considering that the issue relates to accommodation and residence of the two wives, the petition number 1 shall arrange suitable accommodation for both the wives in the interregnum, so as to prevent that both the wives are not facing inconvenience.
My lord, may I record my statement at the bar that the respondent is here at Itanagar, and may direct that I take care of it also. That would, my lord.
It is also directed that in view of the their statement, in view of the statement, in view of the submission made by Mr. Deepangi, consent for the petitioners, to the effect that the respondent number is staying at Itanagar, presently staying at Itanagar. What is it?
My lord, the petitioner number 1 shall.
The petitioner number 1 shall
My lord, take care of whatever needs.
take care of shall take care of the respondent number either in terms of accommodation or any other requirements.
Okay. But in that case, the earlier observation will not be there
Which one?
regarding the accommodation of the two.
Well, see, both.
Because I'm already there.
I said both.
My
Both
lord.
the wives.
The second part, that will clarify. Offline.
Item number 1 and 2.
Your lordship, matter may
Yes.
pass over for some time because
Yes,
um,
we'll dispose it of. Passover for the timing.
your lordship,
Passover for the timing.
yes, your lordship.
Yes.
Item number 3.
Yes. Do you have the records? Do you have the records?
Yes, ma'am.
Okay. Have you checked out the records?
Yes,
When they were given officiating permission?
officiating.
Officiating or ad hoc?
That is
They were appointed, promoted on officiating or ad hoc?
officiating. ma'am.
Officiating.
That
Were
is,
there any vacancy?
yes, my lord. Yes,
They were vacancies.
in the order, yes, they are appointed in direct recruit quota, my lord. That is
Direct-
undisputed, my lord.
Direct recruit quota.
Not. But-
Direct recruit quota.
Quota, my lord. But as per record, my lord, the posts are available, my lord. The order was issued, my lord.
Promotional quota.
Yes, promotion quota available. Though order was issued against the direct quota, my lord.
Ah.
Uh,
Yes, Mr. Tara.
Sorry, my lord.
Where you were lost yesterday? Yes, where you were lost yesterday?
In a guise of a one call, there was a miscommunication. But the case in nutshell is that these petitioners, they were appointed somewhere in 1994 and 1997. Then
94 and 97. How many-
97.
How many petitioners?
yes, the 7 petitioners, my lord.
Yes.
And then my lord will find their seniority list of a JE at page 38, my lord, of the read petition.
38.
38. Type copy, my lord.
38A.
38A, my lord.
Yes.
Martho Kamgo, the petitioner number 1, he was appointed in 1994 as JE. Date of appointment and date of joining is same there. Then petitioner number 2, my lord,
Is it seniority list of?
of JE, my lord. In order to show that that is date of my entry in the department.
What is the date of this?
My lord, date of appointment is
No,
seven-
not appointment. That's the date of seniority list, seniority list.
seniority
When it
list,
was
my-
published and
Yeah,
finalized.
yes, my lord. The date specifically it is not there, you know. But this is a seniority list provided by law.
Yes.
Then below that serial number 2, serial number 141 is a petitioner number 2. Serial number 143 is petitioner number 3. Serial number 144 is petition number 4. 145 is 5. 146 and 147. And their date of joining is already worked out there.
Hmm.
Now, my lord, kindly come to page 45 for a minute. Annexure 2, my lord.
Yes.
This is Martho Kamgo who was appointed an officiating promotion in the year 2008, my lord. By this order, my lord. By order dated 27 to 2008, my lord.
Hmm.
Then petitioner number 2, Kiang Mije, my lord, was appointed by order dated 16/10/2010, my lord.
Next page, my lord, page 48, that is. Then, my lord, this
It's
page,
okay. So and so.
page number 46, petition number 3.
You have
which-
annexed all the promotional orders.
Yes, my lord, all.
Officiating.
Yes, my lord, officiating.
On officiating basis in the skill pay of yes,
Now, my lord will see,
2008.
yes,
Yes.
now my lord will see, these officers,
Hmm.
by virtue of their joining in the year 1994 and 1997 as junior engineer, my lord, they became ripened for promotion as assistant engineer. In the year 2002, Martho Kamgo by 2002, my lord. Then rest of the petitioners by 2005, 2006, my lord.
Hmm.
Now, my lord,
You just read this,
which one, my lord?
page 45.
Page
45.
45. Yes, my lord. The governor of Arunachal Pradesh is pleased to order promotion of Sri so-and-so junior electrical engineer to the post of assistant engineer electric on officiating basis in the pay scale of so-and-so, plus other allowances and admission from time to time in the interest of public service. The promotion is purely on officiating basis against deputation
Against
vacancy.
deputation
Yes,
vacancy.
yes.
Hmm.
The rest, that I will indicate below, that
Yes,
that
yes.
is in their government affidavit also, they cannot deny.
Hmm.
Now, my lord will kindly come to page,
You read the whole.
okay,
This is your basis.
this is my,
Basis of claim.
correct.
So first, basis has to be as clear as noonday.
Right. And make it like a signing
Yes.
in the night. The officiating promotion may be terminated and appointee may be reverted to his original post of
No,
junior.
before that.
Which one?
When a vacancy arising out of deputation of so and so
Huh.
under the department and will not bestow on him any claim for regular. You just
Correct,
read
ma'am.
this.
Correct. ma'am.
You just
Even,
read-
my lord,
You just read this. The entire. Please read entire.
okay, my lord, that I'll read from second paragraph.
Yes.
Yeah. The promotion is purely on officiating basis against deputation vacancy again arising out of deputation of Gumto at the AE electrical as EM executive engineer electronic mechanic under the Department of Hydropower, and this gentleman Miller is already absorbed in the power department hydropower and will not bestow on him any claim for regular appointment as electrical assistant engineer electrical, and the officiating service so render would not count for seniority, confirmation, etc., unless his officiating promotion is regularized by
Regularized by a regular DPC in conformity with the provision of recruitment rule.
is regularized by a regular DPC in conformity with provision of recruitment rule. No quarrel on that. Similarly, all those appointments were made, my lord.
Yes.
Now, my lord has in that
Have you been reverted back at any point of time?
same day, one day I was reverted back, and same day my appointment was
To
also
show that
issued.
there was a break of service. I mean, break in the
There
your
cannot be,
officiating promotion.
you issue the order on the same day. First you revert me.
But you have
Then-
happily accepted that.
No, again, my lord, again on the
Of course,
same
that
day.
may not be relevant. That may not be relevant, but then you have accepted it.
Correct, my
Now
lord.
you cannot question that.
No.
One day, maybe one
There are
day.
reasons for quarreling, my lord. The reason for quarreling is that you have gone to the extent of shooting your arrow to another target where you have given privilege to similar situated person, not to me. You cannot deny, my lord. That, my lord, famous quote is there. Carte blanche actions, you cannot do that, my lord. Anyway,
Yes.
so, my lord, we'll see that
So there are certain terms and conditions.
there can. I agree to
in
that.
your,
Same
officiating
thing.
promotion.
No quarrel on that.
Yes.
Now, my lord, that page 52 to 58 is the recruitment rule.
52.
Yes.
Yes.
In 93 rule, that was for the electrical, my lord.
Yes.
That the earlier, my lord, the PHE, the PWD, they would have a separate recruitment rule.
Yes.
But in that 1993 rules, my lord, 8 years for the degree and 10 years for diploma. In terms of that 1993 rules. Now, my lord, what had happened in 2005,
Yeah.
my lord will note the rule 10 that provides for 10, 8 and 10 years.
Page,
Page, just like this. Page 53, my lord.
53.
Yes. Type copy is at 54B, my lord. 8, rule 8. For vacancies to be filled up, my lord. Page 54B.
54.
54B is the type copy, my lord.
No, 54
Eight.
B.
54B, 54.
This is of what rule?
93 rule, my lord. That is
93 rule.
93. Now, finally, my lord, what had happened is, in the year 2005, there was a discrepancy in the recruitment rule in the engineering departments. Then Arunachal government formulated these 2005 recruitment rules. My lord. That, my lord, will find at page number 59 to 62. And my description is at read petition, in read petition para 7, page 12. My lord.
Junior engineer with degree or diploma in mechanical engineering.
Yes.
Page 54 B.
Yes.
This is
That is 93 rule, my lord is referring.
branch wise separately is indicated.
Now, my lord, kindly come to page 59. I'll take my lord with the facts only first.
39.
Yeah, 59.
59.
Yes. This is a combined recruitment rules for the engineers in Arunachal, my lord. Because the 1993 till 2005, all the PHE, electrical, RWD, WRD, all of them were having a separate recruitment rule. Now government has come up with this rule, my lord, combined rule for the Arunachal Pradesh engineering services, my lord.
So this will hold the field.
Yes, it is by 15/12/2005 notification, my lord. This has settled.
So why we should refer to 93 rule?
That is there in the my lord's judgment because these are requirement. This
93 rule is required.
yes, yes.
Because your promotion would be effect from suppose if your claims is accepted from 2008 only,
No,
not before that.
no, my lord. Before that, I'll come I'll come to that just before that.
No,
my
what
lord.
you are saying is your basic, the primary, your grievances is number one, you were promoted
From the
or
date of
being
DPC,
eligible
from the date of
J to A in 2008,
correct,
since 2008.
correct, my lord.
And when the DPC was conducted in 2022 or
20.
20,
22,
20,
22,
2020 or 22?
22, my lord.
2020,
Yes,
your this period of officiating promotion should have been
counted.
counted
And already, my lord,
given retrospective effect.
yes, 11 seniors who were also not promoted till 2011. And all of us by 2005, 2002, 2005, we were also ripened for promotion to the post of assistant engineer. And the department deliberately have not conducted the DPC.
Sure.
So
No, we'll just clarify. Just clarify this.
yes,
Since your claim is from 2008, why you
Right.
should go back to 1993 rules? Because you are admitting this 2005 combined rules will hold the.
even by
will hold the
2005
field.
rules, Miller, I am eligible. Even by 2005
So
rules.
why should go back to the rules which has already been repealed
Repealed,
and
there,
superseded?
there cannot be automatic revival.
So
of
I'm
it.
asking why? What is the relevancy of 93 rules?
No, Miller,
There's no relevancy.
no relevancy, but only to establish that since our recruitment
that
was
point
done
of-
at that point of time,
Okay.
that was
Your recruitment, nobody's questioning.
No quarrel, Your Honor.
Is there anybody?
No. There is nothing as
So
such.
we'll go by 2005 rule only.
2005 rules only. Because
Yes.
in that judgment, my lord have interpreted. So therefore, I am placing it first.
No, if it is
Refresh-
not relevant,
Huh.
even if this court is interpreted wrongly or rightly in other judgment, we're not concerned.
Right.
It should not be concerned for us.
Now, my lord,
For the purpose of this
yes.
case.
Now, my lord, for one purpose, my lord,
Yes.
kindly come to my type copy is at
Type
page 62, 61.
61, yes.
61, my lord will kindly come to 62A, my lord, that schedule.
Yes.
This, my lord, sometime we call it schedule and sometime we call it schedule. It is this English word is something very interesting, my lord.
Normally,
It is schedule, my
people
lord.
say they're American and English, British English. But we Indian have been forgotten. We have Indian from within India.
Our own version of English.
Yes, we have
So
a
therefore-
we have a Assamese and Arunachal version and go back to Alo version and Paya version is there.
The foundational,
Yes.
functional, and this colloquial English now. My lord, kindly come to 11, my lord. Down bottom below, my lord.
Yes.
The two source of promotion, my lord.
50%
50% by
yes.
promotion and 50% by direct recruit, my lord. Here, my lord, we'll see that the quota quotas would be make rotational. Suppose that is, my lord, we'll see P1, D1, my lord. Direct. P1 is promotee, D1 is direct recruit, my lord. 50-50 means seniority accordingly will have to be maintained in terms of rota quota, my lord. Now, my lord, next kindly see promote 12. Junior engineers,
What's the question of rota quota?
my lord, because it has provided 50% by, because suppose vacancy has arisen in the year 2005 and there was no advertisement, then the direct recruit quota was utilized by the department in our case, my lord. So then it has to carry forward again.
I should go into all this.
Now, my lord, will see this rule were further amended on 14/8/2006, 12/8/2007, and 27/10/2008. My lord, RR is silent about mode of appointment for promotional post of A's on ad hoc. Here, in all the rules, my lord, it is silence. How promotions of A can be done on ad hoc or the officiating basis. All these rules. Now, my lord, what had happened is at page 60, annexure 6, my lord, page 66, my lord, we submitted a representation to the state government.
What is your the 2020 DPC? Is it for regularization or is for promotion?
Regularization, my lord. Regularization.
Are you sure?
Well, let me proceed. Promotion stroke regularization. Then in our case, it is a case of regularization, not the promotion. Because promotion, had it been a case of promotion by holding regular DPC by the authority, then all the petitioner number 1 became ripened for promotion in the year 2002 and rest of the petitioners by 2005.
But you cannot claim it and you are not claiming also. Just because you are eligible, I mean, you have the qualification, I mean, qualifying service. You cannot and you are not claiming in this present petition.
No, we are saying that instead of date of DPC, it should be date of our officiating appointment.
Yes, that's simple. We'll look
That's the
into
only.
it, yes.
Therefore, my lord, now what has happened? There has been a protracted letters between the petitioners and the state government, my lord. So that, my lord, first representation that we submitted is at annexure 6, page 66. 66A is a type copy, that is representation dated 14/9/2012 for consideration our case, my lord. 66, my lord. Type copy is at page 66A. One among us. Secretary power, it was written, with humble submission, I beg to state that I have been serving the department since last 15 years as JE Electrical and AE Electrical. Since I have been promoted to AE Electrical against the existing vacancy post, and now I have completed my probationary periods of 3 years service as officiating electrical. In fact, it may be mentioned here that lots of legal battle has been fought amongst the officers of this department on the matter of seniority, especially the officers on direct recruitment and those promoted department. Consequently, department is hanged in balance due to non-clearance of DPC in timely manner. Therefore, in order to avert such situation anymore, you are requested to constitute a departmental promotion committee to redress the pending case of regularization of AEs promoted against the existing vacancy post by myself. So then what happens is, now I'm going to kindly come to, this is one of the first grievances that we made, Now again, annexure 7, page 67. These seniors of us, up to Pulpa Wangel, in 2012, after this representation was submitted, the department conducted a DPC, but only these 11 were considered, On the recommendation of the Departmental Promotion Committee held on 24/7/2012, the Governor of Arunachal Pradesh is pleased to order the regularization of the promotion of their services, respective officiating promotion as shown below. Date of regularization, all big dates. They were also appointed in these years. Here, this is our grievances. If these who are senior to us, and if you have granted them the retrospective regularization, why can't in our case? The sum and substance of our grievances is this much only. So then kindly come, then we have submitted our representation. Then, that that annexure 8, page 72 to 74. Here is our representation to them, saying that our case should also be considered at par with our seniors, Before that, my lord will kindly come to the DPC minutes. 68, my lord. Type copy is at page 70, my lord. For a moment, A DPC comprising the following composition met in the office chamber of the Chief Secretary on 24/7/2012 at 11:50 AM to consider 70, my lord. Type copy is at 70.
70, yes. DPC minutes for this.
Yes, this how they have taken this decision, Chief Secretary. The DPC was informed that, here the certain facts will come to, will become very crystal clear. The DPC was informed that in the year 2008, based on representation submitted by APST graduate engineers, the state government had accorded one-time relaxation for conversion of 8 posts of assistant engineer, mean for direct recruit quota to promotion quota by order number so and so 2008. Accordingly, the department had considered officiating promotion of 8 A's, namely so and so. Now name I will not take, and that Prupya Wangel. Prior to that, the department had also given officiating promotions of 3 J's as AE, namely so and so, and Sri so and so. This appointment made on officiating basis needs regularization now, my lord. DPC have scrutinized the ACR, ratings, vigilance clearance, vacancy positions of all these A's appointed on officiating basis. On perusal of the ACRs, it is seen that ACR in respect of so and so period are not available. Only his ACR for the period from 2007 to 2008 is available. However, the officer had expired in the month of September 2011. The minimum benchmark required for promotion post of so and so had been good, and that all requisite grading for the period from so and so. Here, the government was very magnanimous, my lord. They have become benevolent here.
You're lucky enough.
Yes. Now, therefore, the DPC therefore recommend regularization of the officiating appointment of all the A's referred to above retrospectively, my lord. Now, these 11 senior were given promotion, my lord. My lord, this one representation, my lord, kindly take on board. It's very important in my case, my lord. Page 72, my lord, is by Martho Kamgo, my lord. Secretary Power. With due humble submissions, I would like to state the following few lines in favor of your kind considerations and necessary actions, please. That, sir, I was promoted as Assistant Engineer AE on officiating basis from Junior Engineer by Department of Power on 2023-2009 by order number so and so. Since then, I am rendering my services for more than 3 years in Assistant Engineer Electrical without blemish as entitled to all benefits accrued to any government servant under relevant rules and any other law for time being. That's
Where did it?
page 72, my lord.
It's okay.
Well, these grievances is there, and we are saying that please consider our case at par with our seniors, my lord. And these was not given any due considerations, my lord. Now, my lord, Annexure 9 is important, my lord. In the meantime, after filing that representation, what had happened, they made an attempt to conduct the DPC on 29/5/2013, my lord. They sought for our ACS, everything we have submitted, my lord, to hold over, but that DPC was never materialized, my lord, page 75 to 77.
Two 2020?
Yes, my lord, 2013, my lord. Here, my lord, petitioner number 1, Martho Kamgo, 2, so and so, so and so. Serial number 3, 4, 5, my lord, 6, 7, 8, and 9. We were asked to submit all the relevant documents for the
It's okay.
DPC. We
Yeah.
submitted,
Yes.
but thereafter DPC was not conducted.
Yes.
And then what had happened? Then that Mindu Punso, one of the senior
In
A,
direction of this
he
court
went to the court.
to hold DPC.
Yes.
within
And then
6 months.
what had happened? After that, again, this table has come up, my lord. So length of services, my lord, will kindly find at page. This was representation submitted by us. Page Annexure 11, my lord. Page 80, 81, well, 82 is relevant. We have that they have shown in the form of tabular forms. This representation is very clear, my lord. My lord will take on board this representation. I will not read it. We have made it very clear.
Yes.
Then, my lord, 379, we filed another representation on 17/1/2022.
It's okay.
Authority did not conduct it. That is Annexure 11. Then, my lord, then pursuant thereto, this impugn order came to be issued, my lord. Page 86, my lord.
86.
23rd June 2022, my lord. On the recommendation of the Departmental Promotion Committee that at 10 June 2022, the Governor of Arunachal Pradesh is pleased to order promotion regularization of
With effect
the
from
following
DPC.
junior engineers. So, and
DPC.
from the date of DPC. Now, my lord, as we say, that please consider our case also, but you have done it. Now, on this
What
portion,
about this other 16 persons? Are they happy?
already,
No, they are happy.
they are,
They are 23 persons.
yes, but they are below us. They are below us.
Yeah.
Now, my lord, kindly see, why I am agitating is at page 88, my lord, that notifications. The notification itself says, the government notification says that you have the power to do this. Page 88, my lord. My lord, this is very important, my lord. Kindly grant me leave to read out, my lord.
Just wait, just wait. This is notification.
Page 88, my lord. This is notification dated 01/07/2022, my lord. This notification empowers the government to consider my case. It is their own notification, my lord.
Yes. Which para?
My lord, three, my
just,
lord. Three.
just read the
Huh.
relevant.
As regards ad hoc officiating functional appointments which were done on seniority basis, but for which no departmental promotion committee meeting have been held in all such cases, DPC shall be held within 2 months from the date of issue of this order. All posts shall be filled in accordance with the applicable recruitment rules, stroke service rules, my lord. Next, my lord. Four.
See,
Four is important, my lord.
impute order, the promotion order is of 23/6/2022. This notification is thereafter, July. From the date of issue of this order.
Yeah, impugn is
It's
June, July,
subsequent to that.
subsequent to that. But then still, once we have submitted,
They cannot, by the notification, they cannot reopen unless specifically they provide for re-DPC. Cannot
They-
have a retrospective.
this does not have the statutory force, my lord.
No, it will not have a retrospective effect too,
Yes.
because your promotion impute order is 23/06/2022.
My lord, the reference was in terms of that cabinet decision, my lord. The
But
cabinet,
then what does it say? You read it.
cabinet has also taken
When
decision.
done on seniority, but for which no departmental so and so have been held
My
in
lord-
all cases.
My lord will come back
DPC
to,
shall.
my lord, kindly indulge to pay paragraph 1.
Hmm. Of
And
page
two-
88.
Yeah, page 88, my lord.
Yes.
Matters regarding one out-of-turn promotion of officials serving in lower substantive posts who have been allowed to officiate or on functions higher posts on so-called officiating functional basis, depriving the senior eligible person of their due date, right to promotions or posting on the higher post, and two related issues have been deliberated in length in the cabinet meeting held on 29/6/2022. I think my lord was also part of this cabinet when the was holding the charge of AG, my lord.
So I'll not take up this matter in that case.
In the no, might
If,
have.
if I
No,
was a part
no,
of this cabinet,
I said might have, might have.
is it?
Yes. might.
You find out first then.
No, that is still there, no. So then the same thing.
It will, it
no,
will
no,
be,
same
it will
thing.
hard to, I mean,
No. Is I am saying might have been.
okay.
Might have been. I have not used the word. There's a conjunctive and disjunctive, my lord. Ancillary words are there. So therefore, my lord, 2 is important. Para 2.
Yes.
As regards ad hoc officiating functional, no. 2, the earlier decision of the cabinet dated 7/3/2016. I think my brother Pangin and all of us have done a lot of cases on this or basis of this shall be is strictly implemented, that is all officiating.
It's not relevant. This three could be relevant, but then it said your promotion has already been
Well,
effected before this notification.
correct, Milord.
So
I bow down, Milord.
two will not be relevant.
No, I bow down, Milord.
Hmm.
Because this is post DPC, Milord. The notification was issued on the post DPC that I did not notice, Milord.
Yes.
Now, Milord, kindly see at page number, Milord, NHF 14, page 96, Milord.
Yes.
This is for one particular purpose, Milord. This is list of direct recruit quota, Milord. That's why I was making an argument that day. If our case is considered from the date of our officiating, then my brother Pangin's client will not be affected by this. Now, since the DPC has held in 2022, then there is a window for his argument for his client. Kindly see, all of them are from 2000. Two of them are 2009, 11, then 12. And before that, Milord, we were already, since 2008, all of us were functioning. Milord, kindly allow me to read paragraph 19 of my read petition, Milord. Page 20, Milord, I am reading for him.
What is this 96? Is prepared by you?
96 is the list of direct recruitee A's.
Prepared by you.
No, it's a government, Milord.
List of A appointed against direct.
Yes.
No, I mean, how the government can prepare an issue like this? This is on what context this has been prepared?
That is to show that how many direct recruitees have been done.
Who has prepared this?
Yes, 53 posts are there.
On what context?
Just to show that they are born in the cadre in the year 2013, Milord.
Who has prepared this?
Department, it's a department records
There's
we obtained
nothing.
through RTA.
This from
It is-
RTI?
Yes, it is there, Milord. I'll show from there, Milord. Now, Milord, can you allow me to read
So by
paragraph?
showing this, what you are saying to, what you are trying is that since they were appointed prior to the, after your officiating appointment,
Correct.
even if you given the thing, they'll not be affected.
Yes,
Given the promotion with effect from officiating,
Yes.
it's 2008
yes,
or 9, they'll not be affected. That is what you are saying.
yes, Milord. So that is one. That's Milord, kindly allow me to read para 19 of my
19.
read petition. That it is to submit that the respondent authorities have deliberately not regularized the officiating services of the petitioners as assistant engineer electrical with retrospective effect, retrospective with similarly situated person only to favor the 31 assistant engineer electrical who were recruited directly through the Public Service Commission from the year 2009 to 2017. It is because if the regularization of the officiating services of the petitioners in terms of the impugn order dated 23/6/2022 from the date of DPC would mean the officers who were recruited from 2009 to 2017 would become seniors to the petitioners, even who were not born in the cadre of assistant engineer electrical, while the petitioners were already working as assistant engineer officiating in the year 2008 onwards, my lord. Thus, the action of the respondent authorities
Okay.
in issuing the
Agreed.
interviews. So now, my lord, this, to fortify my argument, my lord, kindly have their affidavit in opposition just to show the quota, my lord.
Affidavit by the state.
State respondent
and
number
four.
2 and 4, my lord. Kindly come to page 5, para 4, my lord.
Yes.
My lord, the para 4 starts from page 3. We are concerned with, my lord, we are concerned with page number 5.
Yes.
Vacancy position from 31/3/2008 to 31/3/2012, my lord. My lord, kindly come to serial number 3 first, next page, my lord. It is for the promotee. Then serial number 4 also, it is for the promotee, my lord.
Hmm.
Then serial number 5 is also for the promotee, my lord. Then serial number 12, my lord, next page, my lord. Is also for the promotees. Then, my lord, page 9. It is for the promotees, my lord. Serial number 14. Then 10, my lord, serial number 16. Even the individual name is also there against whom this posts are vacant now. 18 also, my lord, for the promotees. 20 also, it is for the promotees, my lord. Kindly come to page 11, my lord, next page. 22. My lord. Serial number 22 is for the promotees, my lord. Then 24 is also for the promotees, my lord. That is total 10 vacancies are shown. My lord, now due date that 26, my lord. P11, my lord. Then 28, my lord. P12.
So
Then, my lord, similarly,
out of 36,
yes, is these were lying vacant till 2000, my lord, I'll say 2012. Till 2012, these posts were lying vacant. And the rotation,
how many posts?
16 posts.
16 posts.
16 posts were lying vacant. We are 7.
And how many have been filled up in 2012?
2012, 8. And that too,
Not 8.
7.
13.
13. No, 7. That page, where is that appointment?
2012, my lord. 11.
11.
Ah.
11.
Now, 11. Say, per se 11, my lord. Now, still,
5.
you have 5 posts are lying vacant. Now, what prompted you not to hold a DPC? You are duty bound to hold a DPC. And because of your delay, someone's right is at peril. Absolutely, there was no application of mine by the authorities. They woke up from their slumber sleep till we file the
So
representation.
these are your basically
Yes, my lord.
primary grievances.
Well, it is from there, my lord. So this,
there were 16 vacancies.
till 2012, my lord.
Yes.
And they came before the
Why
Private-
you have not been considered?
private respondent number.
When this,
Yes.
your seniors were considered, why you have not been considered?
That is why, my lord, there was a hostile discrimination. If I have to be with hers, my lord, that is nullify the exercises of the power
But
to discriminate us.
Why you have not challenged that against those
No,
non-consideration
no, Milord.
when
What
you were eligible
No,
at that
Milord.
point of time?
we have been trying to resolve the matter administratively. Milord, CCS rule is there. If the employees frequently go to the court, he can be put under so many problems under CCS
It would
rules.
be strange.
Yes. Beyond
Totally-
imagination, Milord.
Totally strange.
Yes. No, therefore, Milord, there are representation that has been going on, Milord. Now our simple,
Anyway, that's
now the question
it's
is,
a foregone conclusion.
yes,
You have no grievances against those people,
yes, we don't
11
have,
people.
no, we are not quarreling with them. We
So
are only
according to
making a,
you, there were clear vacancies in 2012, 5 vacancies.
5
5
vacancies.
clear vacancies, 2012. So you could have been promoted. That is your.
That's then, well, this particular proposition of law, Milord, has already been dealt by my lord. Well, I have provided.
Yes.
Moli Tatu, Milord, judgment.
Hmm.
Other day, I was terrified because my brother Pangin says he will dispute on the facts and on law. Then I thought of taking shelter of the judgment rendered by my lordship.
But there could be a difference.
No, my lord.
This is a case of clear cut they have
No, my lord.
established that
My
there
lord,
was a-
same recruitment rule, my lord, have dealt with. Only department is different, my lord. My lord have also dealt with delay in holding the DPC, why these officers should be made to suffer. So therefore, my lord, my lord, and there was a clear vacancy now, my lord, I have seen 2012, 5 clear vacancies were there. My lord will have a paragraph 54 of my lord's judgment.
first difference is in this judgment they were they were promoted on ad hoc basis.
We are also,
You are officiating.
my
There
lord,
is a difference
what,
of
my lord,
officiating
what,
and
no, no, my
ad
lord,
hoc.
there is nothing as such.
And we'll consider, of course, we'll determine the order of officiating or ad hoc promotion, the condition, terms and conditions.
No, my lord will kindly see, this whatever,
So you are relying on this.
My
Any
lord-
other judgment?
no, my lord, that is a gospel truth for me in this case.
No, any other judgment.
No, but then, my lord, other day, my lord has asked that there was a latest judgment.
Weird.
Yeah,
The Supreme
this
Court.
cannot be retrospective, my lord. This is by the Hema Kohli, my lord.
Most probably.
This judgment is, it was rendered on 23rd July, my lord.
Hmm.
Or a copy, hai na, Nikala? There's one more copy was. No, it must be here. Quickly. Page 7, internal 7 onward. Well, these the argument, discussions, legal positions. Now, finally, what law has been held is this, my lord. The fact is bit different than us. My lord will kindly come from paragraph 25 onwards, coming to the internal page 14. My lord can I have some part here? Makes sense on the book, huh?
Relevant.
Yeah, 25 onwards.
I don't say reiteration that there cannot be retrospective promotion to the detriment of others. It starts from page 7 onwards, legal position. All the earlier judgments has been relied upon.
These are reiterations of the principles of law.
Basically, that there cannot be retrospective promotion, my lord. Just because there is a vacancy as erosion, there is no right for promotion.
But the caveat is, if the rule permits,
Rule doesn't say anything.
It doesn't say anything.
rule is
permits-
silent.
Rule is silent.
Silent. So
Yeah, but-
therefore,
According to it's a discretion
if
of the
we-
state.
if we
Is it the discretion of the state? If the
Mighty
rule, if
state,
the,
my
if
lord.
the rule is silent,
Mighty state, my lord, we cannot fight it. That's why we come before this court, my lord, as a last.
no, I'm just asking, if the rule is silent, according to you, it is up to the discretion of. the-
Discretion,
Okay,
that discretion they ought to have. Then, my lord, that,
so if the discretion by the government, unless you can show that it is culpably illegal or in excess, colorable excesses of power, how can we interfere? If they have the discretion. If the discretion is applied,
but this is
and
in my,
acted.
no, my lord, application of discretion is one thing, but how discretion was made applicable is the benchmark for
you
this
make a
question.
submission on that, if you have the point on that.
In that case, my lord, that's why they have taken a special, my lord.
Is it your case? Is it your case?
No,
They have exercised their discretion.
exercise the discretion for 7 people, not in our case.
Have
So-
you made a statement?
We have made it, my lord, in our statement as categorical. If that fiction is to be dealt with, my lord, kindly come to this annexure, my lord, where we have dealt it also. Our seniors were given promotion, my lord.
No, it's okay. We understood that. We have understood that. But have you taken, are these your grounds that the state authority has exercised their jurisdiction in a colorable exercise of power?
That we have made, my lord. We made that your decision-making process is not rational, it is arbitrary. Because you have meted out discrimination to us
But the, if
while
law-
giving a privilege to
no,
another one.
if the law says you cannot have a right to be promoted on retrospective effect, then
Then first thing, my lord, will have to respectfully redissect lordship's judgment only.
My lord, judgment is totally different.
No. It's not,
okay.
because fact, the same rule has been interpreted.
So
made
any
applicable.
other,
No, my lord, just last time.
it's very, very simple. Matter is very simple. We'll determine it in a simplest way. We'll not make it complicated. What we have to see is, first of all, whether you have a right to be promoted with retrospective effect from the date when you are promoted on official basis. What is the terms and conditions in your officiating promotion order? Whether the rule permits that.
Yeah, my lord will wisely apply the
And-
interpretation.
And can you have a right to draw? I mean, can you draw a parallel right to those who have been already appointed, giving the benefit of retrospective effect?
No, my lord, the constitutional mandate and its soul says there cannot be a hostile discrimination unless or until if you are not plausibly established to in fact that there is a intelligible differentia. Now here it is not a case of intelligible differentia. Here it is a case of hostile discriminations. Then what happens, my lord? Article 14?
Can you claim a negative equality? Suppose your friends have been granted the retrospective promotion, dehodes the rule, or against the settled position. Can you claim the same right?
No. My lord, that I cannot. Once there is a law,
Then the concept of negative equality, not the concept, the negative equality comes. And in Supreme Court says there is no concept of negative equality.
that is
It's
why, my lord,
always positive.
that is why, my lord, the beauty of Article
So,
14 is
Yes, so
equality and arbitrariness
so if you
is the
don't-
sworn enemies.
if there is no concept of negative equality, how can you claim a right on the basis of negative equality?
That is what 1992 that Ajit Singh 2 judgment says. I have a fundamental right to be considered for promotion. That has been recognized.
No, we're not on that. That is, nobody is disputing that.
No, my lord, that to overcome
See,
the shown
see, your
enmity
claim
between
is-
the equality
you-
and the arbitrariness, then
you say that since your seniors, number one seniors, you
Correct,
said
correct.
seniors,
correct,
not the equally situated persons.
correct, Milord.
Your seniors have been considered and admittedly by the government, DPC, with retrospective effect. They have been given the benefit of retrospective effect, right? And if that privilege given to them is not permissive under the law, it becomes an illegality.
Then there is
Then on illegality, you cannot claim equality on illegality.
correct, correct. And that,
As you
that,
know,
that,
I don't have to
Milord,
point it out.
that constitutional mandate, I will not quarrel. This is settled
Yeah.
law. I cannot quarrel with Milord.
So you
And
give up,
I have to
you give up,
respectfully go down.
you give up the claim that you should not claim that since your seniors have been given the benefit of this, I should also be
No,
given.
that's why, Milord.
That
No, that's why, Milord, I will respectfully make an opinion to that extent that the authorities, while taking this decision at page 67, Milord, should have applied the doctrine of self-imposed. Because self-imposed talks about the morality of a person holding the office to exercise his power. If consciously he knows that decision that I am going to take
sir,
is against the spirit of 14,
that would be a huge and deep ocean which this court would not like to venture into.
no, Milord,
For the purpose of this,
Hmm.
we'll consider in an appropriate case, right? Not in this
No.
case.
no, but then Milord, still kindly see our grievances from day one
Yes, I've understood your
till
question.
2000, Milord, till 2022 before the DPC, we're saying that, my lord, kindly share our share of little bread so that we can also fill our stomach. And this particular phraseology has come from the French Revolution. And particularly somewhere in 91, 92, that the Russian Reformation, Glasnost and Perestroika, these concepts has
Sir,
come into Milord.
Sir, that's why
So
I,
therefore,
sir, that's
Milord,
why I indicate, let us not go deep inside this deep ocean where you cannot, breathe
because
unless you go with the,
My lord,
the
my lord's
oxygen and all
no, my
other
lord's,
thing.
my lord's
And
question is
unless you are
putting me on
swimming
the
in the
toes.
swimming in the coral island, let us not go into
No,
this.
because my lord's questions are putting me on my toes to come out with those philosophies to
It's okay.
convince my lord.
It's okay.
Well, ultimately, my lord,
No, I'm putting.
art of
I'm putting.
art
a
of
question.
advocacy,
I'm
my lord.
putting a question.
Yes, my lord.
Which
Ultimately,
which is relevant
irrelevant, my lord.
on the basis of your argument. I'm
Sir,
not putting all those
No, therefore, my lord,
philosophical and
dissection-
constitutional issues,
No.
which is not relevant.
no, my lord.
We'll
Otherwise,
appropriate. We'll love to, and we're ready to hear you in the appropriate cases.
one day, my
Alright.
lord, right from the
Every day,
because
we're ready to hear you every day.
correct, my lord.
Yes.
Well, therefore, my
But in
lord,
the appropriate case.
yes, my lord, therefore, in this case, kindly
Yes.
try to balance the equity and to understand
Yes.
the equity, my lord. The concept of equity, although it is not there in our constitution itself, but we have drawn this principle from the Chancery of England, my lord, where it has come.
Again, sir.
So therefore,
Again,
my lord,
sir.
the philosophy,
Again, you are back to the.
no, that's why. Therefore, the concept that has emanated from
correct.
there is incubated in Article 14 and 21 of the Constitution, my lord.
Okay. That's all.
That's all. My lord, that one more clarification that I wanted to give,
Yes.
that Mega Chandra judgment was
Just let's.
Mega Chandra judgment was this thing referred to a larger bench. There is no stay, my lord. That paragraph 35 to 38. In that event also, my lord, if this particular judgment, paragraph 35 and 38, if these are to be looked into, then our seniority is too long, far away. Paragraph 35 to 38, my lord, is the answer.
Paragraph 30.
The 35 onwards, my lord. In any event, the decision in the case of K. Megachandra has a prospective operation. The seniority list of 7 September 2016 was made in terms of the decision in case of NR Palmer. Hence, the same could not have been altered on 13 February 2018 when the said decision was in force. 36. Thus, our conclusion can be summarized as under. The decision in the case of K. Megachandra requires reconsideration by a larger bench in view of the fact that the binding decision of the Constitution bench in case of Mervyn Cotindo and another binding decision of a coordinate bench in the case of M. Subba Reddy were not placed for consideration before the bench which decided the case of K. Megachandra. Even assuming that the case of K. Megachandra was correctly decided, paragraph 39 of the decision shows that the decision in the case of Anna Palmer has been prospectively overruled by observing that decision will not affect the inter se seniority already fixed on the basis of the case of Anna Palmer, and the same was protected. So this and this, paragraph 38, they have said that they need to clarify. This is referred to. But then, my lord, Megachandra judgment still holds the fields because the Chief Justice has not constituted the larger bench to decide upon the correct, to examine the correctness of this Megachandra judgment.
Yes,
So
so
that
this is
is
for the purpose that
for the purpose that if even
this
if that
matter is pending before, it has been referred to larger bench, right?
right.
It's pending reference. And since there is no stay, the K. Megachandra will hold the field.
Then, my lord, therefore, on the strength of this judgment,
Where is K.
on the strength of yes,
Are you relying on Megachandra?
no. On the strength of this judgment, my lord, then if Palmer, because it is a prospective, then what happens? All our past services has to be counted. Considering that aspect also, my lord will see S.I. Ruplal judgment, which my brother Pangin will respectfully defer it. What it matters is the length of the service, my lord.
So you placed whatever
No, my
you are
lord, that-
relying on.
No, nothing much, my lord. Only my basis is my lord's judgment, that
Okay.
Molitatu judgment, my lord. I'll only indicate the paragraph, my lord. No, it is here.
This. It is very good. I get whoever submits.
My lord, that paragraph. My lord, only two paragraph I will stress. Rest
one?
paragraph 45 onwards, I'll rely till last. But two paragraph, my lord, 51.
It's okay.
51, my lord, delay in holding DPC cannot be faulted for denying promotion to the
On the effects of that case.
on the fact of the case and this
Effects
case.
of that.
No, my lord. Similarly, my lord, it dealt it
Yes.
because
We'll
there was a post officiating promotion.
Sir, we'll consider
Yeah.
if it's similar.
And then 54, there was a clear vacancy. In terms of paragraph 4, clause 1 and 2 of 5 vacant posts. That is, my lord have dealt in 54. And the rest, my lord have laid down the law. That is my submission, my lord. But I just, my younger is, I'll come back with further.
Yes.
In terms of my lord, our affidavit, I have no to submit, my lord. Only I will point out, my lord. The appointment order, my lord, issued in early officiating in category in category of terms say to direct recruitment quota, my lord. That was a order, my lord, or pass officiating order. Now, in epidemic, it is accepted, my lord,
But it says, deputation,
yes, one deputation, other, my lord,
rest, where it's.
Other direct
others are where?
46 percent,
I guess the deputation vacancy, then
46, 46.
others.
46 mile. Starting from 46 mile.
What are meant for direct recruit? All of them, except this petition number 1, all of them direct recruit quota.
Mobile kindly turn to page number 15 of my epidemic in opposition, my lord. It's same, my lord, between, my lord, 2008 to 2012, my lord, there was a 14 vacation post for promotion, my lord.
14 or 16,
14, my lord.
where it is,
Page number 16, my lord.
okay,
14 post, my lord.
total vacancy, 36, backlog, 8, post vacancy.
Now, in term of, my lord, earlier the in read petition,
Total
my lord,
post for direct recruit 14 plus 22. Total vacancy for promotion, that point of time,
my lord, that one.
2012.
Now,
47.
in term of, my lord,
Yes,
cabinet-
we said 14, 16, it's 14 only. Only 14, not 16, 14. 14. Yes.
now in
Yes.
in term of, my lord, cabinet decision, my lord, that the petitioner indicate, my lord, at page number 88 in read petition, my lord. The department tried to hold the review DPC also, my lord, to give them restorative promotion, my lord. But that was turned down likely by the, my lord has pointed out that that is prior to, my lord, this DPC, my lord, was prior to this notification, my lord.
So you have tried,
Tried, my lord.
huh?
My lord. In term of that notification, my lord, we had tried, my lord.
Yes.
But that was turned down, my lord, by the competent authority, my lord, saying that no, that this DPC, my lord, was held prior to 1/7/2022, my lord.
Yes. Authority was so kind enough. They made an attempt to give you the benefit. Maybe not permissible under the law, but competent authority has turned down.
That is the submission I'm making.
That's all.
The record, my lord.
Have you noted it down? What he said is, admittedly, you are appointed, only except for petition number 1, you are allowed to officiate on a direct recruit quota.
My lord, in the affidavit,
Affidavit.
no, in the affidavit also shows that on the same day we were terminated, we were allowed to function, and then same day we were also reappointed. Kindly verify from their affidavit, my lord.
Yeah, that is undisputed, my lord. That is
Undisputed,
undisputed.
my lord.
Okay. See, mere continuation, allow it to continue, do not give a right.
That is not against the direct
My
quota.
view, this court view is, if there was a clear vacancy and if you are eligible, just because there was not a DPC, why you should be punished? I mean, why should your right to have that promotional post should be taken away? That's the simple,
Oh, my
to
lord,
the
I
best
can,
of the understanding of this court.
my lord, as an officer of that
Therefore, you
court,
have to establish that your appointment on officiating basis on clear vacancy at the relevant
Clear vacancy,
point of time,
Yeah.
you were eligible in all respect. That has to be.
right? my lord?
But the hurdles here is, according to the government, your appointment
Yeah,
was
yeah, so.
with certain terms and
Okay.
condition.
Yeah.
petitioner number 25.
May not kindly see this petition number
Yes,
2.
I'll come back to you.
Yeah.
That is, you take note down because you have to reply to that.
Marking karo. Just mark.
Yes,
Wait, wait, wait.
yes. You file affidavit.
Yes, I filed it.
Yes,
That the state, my lord,
yes.
is not submitting much. And from the affidavit, where they say there were 14 vacancies as of 2012, there appears to be something rotten in the state of Denmark because the record does not reveal so. In fact, they have not shown it, I will show it. The DPC, in fact, they say, from the DPC minutes, it appears all these promotions, these 22 promotions, 2022, they appear to have been promoted in vacancies of 2008, 9, and 12. But their own records furnished to us under the RTI does not reflect so. They have said so in the DPC that there is no material to substantiate them. Absolutely incorrect. My lord will kindly have my affidavit. Okay. 5 to 24.
Now, how you will agree? Admittedly, you were appointed
Yes,
on the direct recruit quota
yes,
after 2008, 9.
yes. So if they are given promotion from 2008, obviously they will be made senior to us. That's how
No.
I agree.
You take it in if the person accrued a right
Yes.
to be considered before you born in the cadre, how you will be?
They were never born in the career, they were born in the career 2020.
No,
my lord.
suppose,
Yeah.
if they were entitled to be considered for promotion,
They were not entitled.
at
That is what I'm going to
that
show.
you have to establish.
Yes, exactly.
Since they are not, that you have to show in that case, that since they were not entitled
Yes.
to be considered for
Yes.
promotion,
Because there were no posts.
that you have to establish. Otherwise,
First, my lord,
yes,
if we are coming to your lordship judgment, Modi Tatu,
yes,
that was in respect of clear vacancies. Totally different to the present facts and circumstances of the case.
yes.
Now you lordship, I kindly have my affidavit, 5 to
Yes.
24.
Yes,
Page 105.
105.
Type copy 106. It's legible enough.
Hmm.
This is the requisition sent. Direct recruitment, 105.
105. Yeah. Type copy is
Type copy is 106 onwards.
here. Let us go to the type copy.
Yes. 107.
Mm. It's 17. Yes,
With reference to the subject and letter number quoted above, I am directed to state that 4 posts of assistant engineer to requisition to order to the Public Service Commission, white hour number such and such, dated 28/7/2009. With the request to fill up the post for direct recruitment process, out of which 1 post of withdrawn pursuant to High Court order to accommodate Sri Kripak Didi against vacancy made for telecommunication on recommendation of public service was appointed as successor. Further, after recruitment process, the Public Service Commission recommended 1 successor. Considering the requisition made on 28/7/2009 and 22/9/2000, total number of assistant engineers became 22 numbers. So distribution of posts against the category shall be as under.
yes,
So that this is the requisition. Now your lordship will have the file noting at page 109. This is on 30 August 2011.
this is requisition
Our
for,
requisition.
this is for 4 posts.
No, madam, 22 posts.
Here,
Yes.
okay. Yes.
Now your lordship may kindly have page 109.
Hmm.
This is on 38/2011. With reference to the direction of secretary power on 38/2011, in presence of unemployed youth wherein it declares that the vacancies are to be placed requiring the Public Service Commission for conduct of recruitment process. In light of this, vacancy position has been worked out as under. Clear vacancy due to creation of unit and post 7. Vacancy due to retirement and death 5. Backlog 2. Vacancy due to promotion 9. 23 numbers. Now I will see. In this regard, it is to inform that as per recruitment rule, the post of assistant engineer has to be filled up 50% by promotion and balanced by direct recruitment. Since the inception of power department, the government has appointed 82 assistant engineers through promotion
Yes.
and 65 assistant engineers through direct recruit process. 17 more. A copy of this of age appointed to direct recruitment process and promotion is placed below for perusal. Hence, out of 23 number of posts, if we keep 17 number of posts for direct recruitment quota, the quota comes to 50-50, i.e. it comes to 82 posts through promotion and 82 through direct recruitment. And for the remaining 6 posts are to be divided equally for promotion quota and direct recruit quota. That is 3 posts for promotion quota and 3 posts for direct recruit quota. So 17 plus 3 for direct recruit, by the way, will keep a note of the 3 that has been kept for a promotion quota. This is in 2011. 3 for promotion.
Okay.
So as on 38 to 2011,
So they have
they
filled
have
up
excess promotion.
they have already
Exceeded.
filled up 4
Yes,
in 2012,
yes,
11.
yes.
Then
17 posts extra.
ah,
So
No.
where is the vacancy?
no, they have promoted 11
In 2012.
assistant engineer 2012.
That is why I was
During
pointing out.
that period of time, during that relevant point of time, they say that there are 14 vacancies
Yes.
for promotion. So these 3 and that plus 4,
Plus
I mean 11.
8.
So it's become
No,
yes.
3 plus 8. I will show the minutes. I will show.
Okay.
I will kindly note that there were 3 vacancies for promotion.
Hmm.
So as on 38 2011, there are only 3 vacancies for promotion.
Yes. Okay. Hmm.
Thereafter, a requisition was sent.
Of what? 22.
Yes. 20. Others are for the mechanical and other things.
20 posts.
Yes.
From we get it from this page 9. Oh, sorry,
Yes.
105, 106.
105.
Hmm.
Yes.
Where do you get the figures?
My lord.
Where do you get the figures?
Ultimately, my lord will
The
say.
total cost of assistant engineer electric will come 22. So distribution of post. This is the total post.
Yes. Total post.
Total is 22.
22.
So distribution so and so.
Yes. This is the requisition, my lord. Ultimately, advertisement was issued for, my lord, 20. At page 117.
I'm not able to get it. Page 105.
105 is the
Considering
requisition.
requisition made on
Yes.
so and so, the total cost of assistant engineer electric become 22.
Yes.
Numbers show distribution of the post against its trade.
So they are saying
13
electrical engineering
electric engineer,
13.2, mechanical
Electronic
engineering
6.
6.6.
Hmm.
But ultimately, from the file noting, my lord,
Hmm.
what is revealed is 17. There was a backlog of 17 for direct recruitment, and the 6 extra posts, 3 was to go to direct recruitment, and 3 for promotion. That much is clear. Is 109.
Very difficult.
109.
From 105, I'm not getting 20.
Yeah, 105, my lord, they have how calculated. I am also not very sure.
20 or 20, it is like, what do you read? 13 plus 6, 19.
Yes.
And then if you take this appointed Sri so and so and both this, it comes to 21,
It appears.
not 22.
My lord will kindly have the file noting and the subsequent advert. Ultimately, the advertising was on 20. From the file noting on page 109, what is clear is there are 17 backlog because 17 more promotions were made.
Where is this page?
109.
Nine.
I'm reading again. 109. May I read again?
Yes.
So after the total numbers,
Hmm.
in this regard, well, I will just show clear vacancy due to creation of unit and post 7, vacancy due to retirement and death 5, backlog 2, vacancy due to promotion 9,
Hmm.
total 23 posts. In this regard, it is to inform that as per recruitment rule, the post of assistant engineer has to be filled up 50% by promotion and balanced by direct recruitment. Since inception of power department, the government has appointed 82 assistant engineers through promotion and 65 assistant engineers through direct recruitment, meaning thereby 17 more has been promoted.
Yes.
A copy of such a direct recruitment promotion is placed here. Hence, out of 23 number of posts, that is the clear vacancy at that point of time. If we keep 17 numbers for post of direct recruitment quota, the ratio comes to 50-50, i.e. that become 82 each through promotion and 82 posts to direct recruitment. And for the remaining 6 posts are to be divided equally for promotion quota and direct recruit quota. So 17 that was excess plus 3, 20. 20 was advertised, I will show. That is why I am making that these 3 posts for promotion, my lord, may kindly take a note of it. 17 plus
So out of,
20,
by this, out of 23, 20 were for to be filled up
direct recruit,
direct recruit and 3 were for
promotion.
promotion.
My lord, you see the advertisement, almost one.
Page 17.
117.
13 posts. 13 posts.
117.
117.
Yes. Same post. Where it is?
Applications prescribed for were invited from citizens of India for filling up 20 posts of assistant engineer electrical. So
Okay.
20, 17 plus 3. This is dated 23 November 2011.
But the requisition of 105 is not clear.
May not take note of that. That is
It's 21 only.
Yes. Ultimately,
Anyway.
electrical 20. This is where we are filled up. So we participate in the selection
Okay.
process and the result notification 119,
It is 23rd November 2021.
2011.
Oh, 11.
So in terms of the file noting, in the file noting is dated August. So August 2011, when the selection process was going on, there were only 3 promotional posts.
Hmm. Yes.
Minor is already post 1.
Hmm.
Come back at 2 now.
This way. But continue for some time.
Later, minor will come back so that I can be true. Minor. 3 promotional posts and 20 direct recruit as of 2011 November.
Hmm.
I'm pointing this out, my lord, because these 3 posts of promotional post was filled up in 2012, along with the 8 converted posts.
In 2000,
Well, but I will show, I will show. I'm just quoting.
2011.
Yes, there are only 3 promotional posts and 20 for direct recruits. Clear? As per record. That's what I was saying. The affidavit filed by the state is not substantiated. They have just
But
filed it.
how long you will take? Another 10 minutes?
Maybe 20
We
minutes.
have yet to, proceed with the list.
Yes, I understand. This has been taken up, but I will 20 minutes at least. I have to show the document.
My lord has something
much?
in the
How
afternoon.
long?
20.
20 minutes.
20 minutes.
You finish it up.
And 5 minutes rejoined.
Is that fair?
Then 30 minutes
Yeah, 30 minutes.
for all.
The state is not saying anything. After filing the affidavit. My.
Affidavit.
Yes, my 5 to 24.
Yes, advertisement.
Yes. 17 post, my lord, that was excessively filled up on the promotion quota, that was given to us now, and the 3 post. So, advertisement for 20. This is dated 23rd of November 2011. 119 is the result notification, 20 post. 12 July 2013 is an example, my lord. This is the offer letter. And my lord, 122. This is dated 18th of July 2013. Our appointment letters. 18 July 2013. 122. So that is how that 17 excess promotional that was done. Plus 3 that was given to us was filled up. Starting from the advertisement and culminating in the appointment letters dated 18/7/2013.
Yes.
Now, my lord will see how the 3 posts that was left for promotional quota was filled up. My lord, will kindly have the affidavit of the respondent number 2 and 4. Page 30 of the respondent number 2 and 4.
Yes.
Type copy 32. Madam, will kindly note this is dated 24/7/2012. A DPC comprising the following composition met in
Yes.
the office chamber of this type of the chief secretary at 11:50 AM to consider the regularization of the officiating promotion of 11 assistant engineers. The DPC was informed that in the year 2008, based on the representation submitted by APST graduate engineer, the state government accorded one-time relaxation for conversion of 8 posts of assistant engineer meant for direct recruit quota to promotional quota. My lord will see here also 2008, 8 posts meant for direct recruit was converted into the promotional quota. So all these 8 persons were filled up against that. I'm not reading the names.
Yes.
Then my lord will see. Just before the second line from the conclusion of this paragraph, my lord. Prior to that, department has also given officiating promotion to 3 junior engineers as AE, namely such and such. So 8 converted posts and the 3 posts that remained, my lord, 3 promotional vacancy was filled up by this DPC.
Okay.
24/7.
So it's become 11.
Yes, 11.
8 plus 11.
Yes.
Even after conversion.
Yes. 24/7/2012, there is no promotional vacancy. Admittedly, all these promotees are senior to the present petitioners. So that is how it was filled up. Now, my lord,
Requisition was in 2011.
my lord,
Requisition was in 2011.
yes. So
And
apparently
it is
before that-
culminated into 2013.
yes. So when this was going on, our recruitment process was already underway. So as on 24/7/2012, there is no promotional vacancy, not a single one. Now, my lord will
But
see.
why they are saying that there are 14 vacancies?
That is what I am saying. There is something which is rotated in Denmark. These are RTI documents. There cannot be any vacancy. Now, my lord will see how, my lord will revert back to my affidavit. I have to. They have filed an affidavit saying that there were 14 vacancies. Not a single document to rebut these documents. These are their documents, all obtained through the RTI.
All 11 converted posts.
Yes, 8 converted posts plus 3 that
8.
was meant for promotion. 8 plus 3. There were 6 vacancies. 17 was granted. There were 23. 17 there was a backlog. So 3 given, 20. Then these 3, 12/7.
Yes.
Now, how they were appointed? 124. Petitioner number 1. Third para onwards. Third paragraph. The promotion is purely on officiating basis against deputation vacancy arising out of deputation of Sri Gumto Hete, A electrical SEENM under the Department of Hydropower Development.
Okay,
Can-
we've seen that.
Yes.
We've read.
Now, my lord will kindly have 128.
Ah.
This is P3 and P4.
128. Yes, this also
Direct recruitment.
direct recruit quota.
And it is clearly stated that once our appointments are made, they will be reverted back.
Okay.
The officiating
Page
appointment
20,
is against the
page-
quota meant for direct recruitment of AE and S and when direct recruits are selected by Public Service Commission, their appointments will automatically stand terminated.
Yeah.
Clause 3. P3 and P4.
Hmm.
P2's order is at page 130. It appears his junior were given officiating promotion, the approaches Honorable High Court,
So he was also
he
given.
also given. Clause 1, the officiating appointment is against direct recruitment quota, which has already been requisitioned to the Arunachal Pradesh Public Service Commission. Therefore, as and when the select list of candidates for direct recruitment is received from Arunachal Pradesh Public Service Commission, he shall automatically stand reverted to his original post of junior engineer. Clear? Already requisition. Because 4 were requisition at that point of time earlier. In 11 posts were added. 4 already under requisition. Then my lord will see at page 132.
Yes.
This is an offer, my lord. Serial number 2 is the P5.
Hmm.
Serial number 4 is the P6. Serial number 6 is the P7.
Hmm.
Along with others. The following junior engineer electricals is offered a post of assistant engineer on ad hoc against the direct recruitment quota with the following terms and conditions. Yes, stopgap arrangement. The officiating ad hoc shall be against direct recruit quota. They shall have no claim for continuation of appointment once the Arunachal Pradesh Public Service Commission select candidates for appointment to the post of AE. They will be reverted to their substantive appointment as JE once their appointment is discontinued. This is the offer. And the order is at page 133. Same terms and conditions.
Hmm.
The officiating appointment shall be against direct recruit quota. They shall have no claim once the Public Service Commission selected for appointment to the post of AE. Same. So the my lord judgment does not apply. Because it has totally different facts and circumstances. There were clear vacancies. Inspector Rublal does not apply. Inspector Rublal is a proposition, my lord, when somebody in an analogous post serving in a different department comes to a on deputation, is subsequently regularized, then his services in the analogous post has to be counted. This is not the case. So they cite the judgments, my lord, regarding retrospective promotion.
Yes.
Because there is no vacancies here, my lord. These judgments are in fact irrelevant actually. But I will just cite, my lord, I will not read out.
Yes.
1991 Supply 1 SCC. Dr. Sachin Dana.
You just. Yes.
I will just, otherwise I will give.
You just give.
Yes. I relying on 3 judgments, my lord. Approach is Sachin Dana, there is 2019-16, and my lord, 2022-6 SCC 105.
Yes.
And
You just give the printout.
okay.
It will be easy. Or can you print out? Get it print out. You just give the.
This
title.
thing. And I'm relying.
Para 17 to 28, this additional AG RH Navam's argument, all his judgments are reflected.
Anyway, we'll determine it.
What I am saying is, these facts are totally different. So, the one of Gomez affidavit saying
Hmm. 14
that
vacancies.
there are 14, that cannot be true. In fact, what I feel from the minutes of the DPC, it appears from until 2012, they are showing 17 vacancies in fact. What I feel is, it must be that 17, my lord, that was given to the promotional quota. That must be. Because the documents reveal, as on 24/7/2012, there is not a single promotional vacancy. How is this affidavit being filed? Then there is no material to substantiate that.
You just give the citation. You might forget.
My lord,
1991.
1991 supply 1,
Hmm.
SCC 334, paragraph 12,
334,
paragraph 12.
12. Ah,
2019 16 SCC, page number 28,
Hmm.
paragraph 45 and 51.
Then
2022 6 SCC, 105. 2022 6 SCC 105, para 18 to 21. Manpreet Singh.
Manpreet.
Poonam.
Yes.
And my lord, I am relying on this, my lord, this recent judgment.
With this, what is this?
What? This is Bihar State Electricity Board and others versus Dharamdev Das. My lord will see, the claim was, he was promoted on 5th of March 2023.
Hmm.
And he wanted that the said promotion should be from July 1997, where the post actually fell vacant. Now, this is not even applicable because there was no vacancy. This judgment, in fact, are not.
Even if there is a vacancy,
Yes. Then I
According to
I
the
would have relied.
Supreme Court said that no, you don't have a right.
Yes. Even if
Just
vacancy there
because
is, yes.
you are eligible
Yes.
or just because
Yes.
there was a
Yes.
vacancy.
But here, my lord, where is the vacancy?
But they have shown vacancy,
They have not.
at least 3.
No, no, my lord.
No, I've considered yours, but according to them, 14 out of 14, 11 have been filled
That
up.
is why I have shown documents. They have not. Where is the document substantiating it?
Yes. That's okay.
Yes. My lord, my lord, one more thing.
Yes.
There is no material in the government affidavit showing any vacancy position. Paragraph, page 96 of the writ petition.
96.
Yes. And paragraph 19, my lord will kindly note, they have themselves stated there are 31 persons, direct recruits,
Hmm.
who are going to march over them.
There are 19.
19, yes. My lord will kindly note, there I refer to. Paragraph 19, they have admitted that there are 31 persons. Only 20 are before your lordships. We have completed ourselves.
19.
Now, page 96. Writ petition.
Yes. Yes.
1, 2, 3, 4, and 5 are not before your lordships.
Hmm.
25 to 31 are also not before your lordships. Any order your lordship passes in the petitioner's favor, they are going to be effective. There's no join there.
Who are they?
One, serial number 1 is Sabda Yomsa, Taso Tatum, Toko Soni, Pinky Lago, and from 25 onwards. We have implemented ours.
Yes.
So in the absence of any vacancies, my lord,
Hmm.
where is the question of even if your Molin Tatu is applied also? No vacancy. That's it.
Yes. Have you checked the record?
Report I have placed, my lord. About my lord vacancies, my lord will kindly have a look at the para 4 of my epidemic.
Yes, I have seen that. Parapur, I've seen it.
These orders are also not in the affidavit.
Therefore, report is, my lord will kindly have a look.
Because
Vacancy,
file noting
there was a
are through the
vacancy.
RTI Act.
There could be vacancy, but then not 14.
According to my detailed epidemic, according to department, from 2008 to 12, my lord, the clear vacancy, it was 36 post, my lord. Now, in terms of 2012, there is 8 vacancy,
14 minutes.
Backlog vacancy where they are.
It was also converted post.
Therefore, my lord, from
Directly post was converted for this 8%.
yes,
Right.
therefore, from 36, my lord, if we minus 8, my lord, it becomes 28 post, my lord. Now, if 28 post by 50-50 ratio, it's 14. Now, at that point, for direct 14 plus 8, it is 22. That is the epidemic. Now,
No, no,
how
but
this
record shown by Mr. Pangin is something different, contrary to what you are submitting.
That's a my lord, can have I have placed a produced a record, my lord.
File notings are at 109 of the my affidavit. In the RTI they have given.
In each column, my lord,
It is on August 30,
6.
2011.
They have mentioned how this vacancy arise, my lord. In the suppose in page number 6, my lord, you see, my lord, due to the promotion of own saying, my lord, that this one vacancy arise. That detailed explanation is there.
Where?
In para 6 of my opinion question, or page number 6, my lord.
So how do
My
they
lord-
explain 109, my lord, then? Department. Their own file noting. Something is very fishy. How do they explain 109?
Yes, you explained.
How do they explain 109?
For that, my lord, categorical,
He has said by documents, what he has said is the as per rules is 50-50.
50-50.
So to make it 82-82 total, right? That point of time, only 3 posts is for the promotional post, right?
Even.
Then you have converted 8 another posts of a direct recruitment for promotion. So these 8% have been filled up by promotion. Anyway, they cannot have any grievance. That is done, what I'm saying. Then 3 promotional posts. That has also been filled up. So it's become 11 in 2012. And the requisition was sent to the Public Service Commission for 20 posts.
21.
Therefore, your affidavit and his submission is, it doesn't tell you. And he has relied on your documents, office noting, file noting and all.
That is, my lord, this particular document, my lord,
Where is that file noting?
file noting, my lord. For this, my lord, I need to take,
No, I've seen it in the file.
for is it this, my lord,
You
I
find
need,
it out. You take the affidavit of his affidavit, wherever you just show it, you find out where it is that file noting. It's from the department only.
Yes. RTI, Deputy Secretary.
my lord.
Yes.
This is he's mixing up the thing. This
What are you mixing up
is for requisition, my lord. My lord has called for the record of the officiating appointment of the petitioner, my lord.
Yes.
That I have produced, my lord. This record will be not available here, my lord. This is requisition sent to the APCS, my lord.
Okay. At that point of time, according to you, there was a vacancy.
But that is a categorical statement as per department. I have placed on report, my lord. That detailed explanation given, my lord. You can see.
But the problem is, there was a vacancy, therefore they were appointed. Is your case?
Hello.
Vacancy was there
My lord.
because there are another the 8% or 11% who is above them. Obviously, they will have a better claim, and accordingly, they have been promoted. There's no dispute.
No dispute.
Vacancy HS might have been there, were there. We'll admit that. But problem is thereafter, whether they were appointed on officiating basis or promoted on a vacancy, or a clear vacancy or not. That is what we would like to know.
No, my lord. About the appointment, my lord.
The regular vacancy, or we have understood, maybe there are 30 or 40, we don't know.
My lord. Appointment was issued against my lord in term of the appointment, but that is in category
Deputation vacancy as well as
as
direct.
direct recruitment. That is category in the order, my lord. That we have filed,
So why we have asked for is whether at the time of his appointment on officiating basis, we have seen this today. That it has not been appointed on a regular vacancy. It was either deputation vacancy or direct recruit quota. All the petitioners.
my
So
lord,
what you are trying to project, what you have projected is the overall whatever.
my lord.
Still then, overall at that point of time, from 2008, 9 or 10 or 11, in this period, the overall vacancy you have projected.
I'm trying to put the correct pixel position, my lord, at that point of time. Well, as per the epidemic of the department. That the humble.
But what we wanted, what this court wanted is that at the time of his appointment,
No.
of course, we have not gone into those documents on the other day. The terms and how you have appointed, what is the vacancy, on which vacancy you have appointed. So when we wanted to know when they were appointed,
Well, the
were
answer,
their vacancies.
well, yes, I assist.
Now,
Page 45.
on the base of the appointment orders only, provision order, official provision order, there is no vacancy.
No, that is clear, ma'am. In terms of the appointment, that is clear.
Well, the answer,
Just wait. Let the government clarify. So according to you, overall vacancy was 14 at that point of time,
My,
all these 3-4 years.
my.
So out of that, you have filled up all.
No, my lord. No, at that point, no promotion posts are filled up.
What point? When?
Between 2008 to 12, my lord.
12.
No. Though vacancy was there, my lord, this
Okay.
petitioner, my lord, was given appointment in the direct recruitment quota, my lord. The order was issued in the direct recruitment quota, my lord. Though
So,
vacancy was
so
there.
according to you, whether they were 10 posts or 14 posts, according to you, they were 14 posts
14
for promotion. But in any case, these 14 posts have been filled up by 2013, 12.
No, my lord.
How?
As my, no DPC was in my lord. That's all, my lord. No DPC was there, my lord. The department did not look into whole those things, my lord. Instead of that, my lord, as they were senior, my lord, they were direct given appointment saying that they are appointed for direct recruitment quota, my lord. So no DPC was had, my lord. So the department did not look into all those aspects, my lord, whether there was a vacancy or not, my lord.
You have filled up in 2012.
Yes.
On regular basis. 11%.
12, my lord, 12 was not, DPC said, 12 DPC said, they those person, my lord, who is fill up in direct recruitment quota, my lord, for under one-time relaxation, my lord, was converted into a promotional quota, my lord.
So according to you, this 14 post is in addition to the 8 posts.
8
plus
posts,
3
my lord,
posts.
8 posts.
Where you have stated, let us see.
Let them substantiate, my lord.
From page number 5, 6 is start, my lord. Now,
Page 14 onwards. Page 14 onwards.
6 is start, my lord. My opinion is 6, my lord. This is a follow my lord. It pass on name is mentioned, my lord. Now vacancy here, my lord, 2008, my lord. How vacancy is, my lord? That is mentioned, my lord.
Very clear.
Mentioned, my lord, is mentioned, my lord. Thereafter, my lord, will kindly directly turn to page number 14, my lord. 14, my lord. Page number 14, my lord. Now, from above table, it is evident that between period 1/4/28 to 31/12/2026, their accommodation total 36 posts of assistant engineer. However, as per the report of the minor meeting of DPC dated 2010, there were 8 backlog for direct recruitment quota due to conversion of 8.
Reading where?
Page number 14, my lord.
14.
14, my lord.
In your grade.
Page 14.
40, my lord.
Yes.
14, 15, 16, my lord. We have explained, my lord. From above, it is evident that between period 1, 428 to 31, 12, 12, their accumulation total 36 posts of assistant engineer. However, as per the record of the minor meeting of DPC dated 24/7/2012, there were 8 backlog for a direct recruitment quota due to conversion of 8 direct recruitment quota posts into proportional quota bid, such and such. So after taking 8 out of the 8 backlog posts for direct recruitment, the total vacant posts between the period 1 for 28 posts. Therefore, in terms of 50-50 ratio for the direct recruitment promotion as per 11 recruitment rule, there are 14 posts vacant each for direct quota and promotional quota between the period 1 for 28 to 31 12.
There were 14 vacant posts, each for direct recruitment quota and promotion. Okay, 14.
Well,
You have just, according to 20 out of 28 posts.
for direct, it will be total 28 because, sorry, my lord, 22 because of 8, my lord, early conversion of direct recruitment to the promotional post.
See, it cannot be. See,
I need to
36,
debug
how
the
many,
respondent also.
out of 36,
My lord.
how many were there for direct recruit? You just cannot divide just half the thing, just because it's a 50-50,
My lord.
without determining which post is direct recruited. Just because there are 36. So you out of, if 38 is taken out,
See,
it's
okay,
become
have to take
28.
into consideration also.
and then you just make it 50. 50-50. It is not the way.
No, my lord, this whole calculation, my lord, I mean, this.
See, 8 posts for direct recruit. The 8 posts of direct recruit quota was taken away, converted. You said total post 36. Out of 36, how many posts were for direct
No,
quota?
Up to, my lord, that way, my
Direct
lord,
recruit or promotion?
up to, my lord, that way, my lord, up to.
Sir, are you aware of determination of how to determine
Yes, my lord, up.
the ratio is how the ratio is work out? If the post is 50-50 ratio for direct recruit and promotion. Just because today you find that there are 100 posts,
My lord.
will just make it 50-50 each. It appears that you have done so.
No, my lord, that way, my lord.
Tell us how many posts are for direct recruit quota out of 36. 36.
36, my lord, 22, my lord.
22.
22.
36. Why 22?
22 because, my lord, before 2012, my lord, there was a DPC only one held in 2005, my lord. Till 2005, my lord.
Why you have explained that?
That this is part of this phase only, my lord.
Okay.
Para four, my lord.
For our understanding, just tell us.
My lord. Till
Out of 36 posts,
my lord, till 2005, my lord, there was no dispute, my lord. All the vacancy, my lord, any, my lord,
till
80
2000.
2005, my lord.
Okay.
Last DPC,
There's no dispute.
my lord, prior to 2005, there are no dispute, my lord. All the out of 84 total 80, there is no dispute, my lord. So, my lord, after 2005, my lord, only DPC has 2012, my lord. Now 2012, my lord, this vacant 2012, this there is conversion, my lord. Now from 2005 till 2005, there are no dispute, my lord. These are equal, my lord. Therefore, my lord, the vacancy from this, my lord, this period, my lord, will be equally divided.
I'm sorry, sir.
Now, I am in this calculation, my lord.
Forget about 2005 or 2020.
My lord.
Since you said there are total 36 posts.
My lord.
What are how many posts were there for direct recruits and promotion?
That, my lord, that,
It cannot be just 18.
that we have indicated in the column, my lord. My lord,
Yes,
we have to say,
that's why I wanted to see.
my lord.
Yes,
Page number 6, my lord.
total vacancy, yes, 15. Backlog.
Page number
direct
6, my
recruit.
lord. Start from 6, my lord.
Vacancy goes down after session 28 posts. Consider 50 as a 14 posts each. So total post of direct 14 plus 8, 22.
D1, my lord, D1 means, my lord, direct, my lord.
D1. D1 is promoted.
D1. Oh, sorry, promotion, my lord. P is promotion, my lord. P indicate promotion, my lord.
So according to you, out of 36, 22 were for direct recruit.
The direct,
Direct recruit,
Direct.
22.
22.
22.
22. That include 8, my lord, that was converted in 2018.
So it become 22
22.
and 14 for direct recruit. I mean promotion.
Promotion.
So how it is possible? On what basis you are saying? If it is 50-50.
50, oh, yes, there's a
See, let us first take on 36 posts.
36 minutes.
If it is 36 posts, what will be the ratio?
13,
18.
18.
This is why I'm saying you cannot just divide like this.
Right.
You have to work out from which post, where it can.
What we have done, my lord, in my lord, have a look at table, my lord, that we have worked, my lord.
Okay.
For direct, suppose, my lord, serial number 1 is D1, my lord. Row number, column number, my lord, 1, 2, 3, 4, my lord, we have worked, my lord, whether it is for promotional or it is for direct, my lord.
Okay.
That's why it's done. Then from there, 50 ratio is started. Okay. Plus 822.
So there were 14 posts,
14%.
2012
Well,
till 2012. So you have filled up 11. 11 in 2012.
Correct.
well,
So what about these 3 posts?
my lord, for this, my lord, for specific this reply, I need to instruct instruction, my lord, to reply this, my lord. For this, I have no instruction, my lord. The documents, my lord.
Because, of course, it's subject to determination by this court. What he's saying till 2012, 2008 to 2012, there were altogether 36 posts. Out of 36, they have indicated in the table, which he has also shown, that on the basis of these records, I mean, promotee and direct B2K, they have worked it out. That out of 36, 22 posts is indicated to be direct recruit quota.
Including 8 backlogs.
So this out of 22, 8 has been converted into promotional quota. So that 14, what they are saying is 14 promotional quota, it remains because it's as per this table,
That's why I'm saying.
it's a promotion.
Only misquoted. This contributed all documents. How can they say this? What about 109?
Yeah.
How are they saying this? Because from what I have saw, apparently it appears as on 24/7/2012 promotional quota filled up.
Can you produce this documents.
This mine is, they have to
Minus-
respond to this. This mine, their document, not mine.
Do you have that, have you given that? copy to him?
No. He has not read it. That is why the difficult.
You bring it tomorrow. We'll continue.
How do they?
We'll just
come
clarify
over
the
this
factual
100
thing.
100
Legal issues comes later.
My lord,
How can they have come over
That's
this
one
109 document?
no, 109, my lord. Has it been culminated into an order?
No,
I
no,
don't
that-
think so.
That's what
If
I'm
it is not culminated into an
That
order,
is totally different proposition of law.
how that can be? That's correct.
No.
If
it's a
there
totally
is no
different
culmination of an
document.
order,
Unbelievable.
no.
Yes,
Nobody is
Mr.
challenging
Preme,
the correctness of this
tell you.
document.
Tomorrow, my lord, it would not be possible.
What is to be
After
done?
spending the whole day, man, on this. This is why I said all records. I knew, I saw the affidavit, that's why.
But my lord, only thing is, my.
You have
case-
any reply?
Yes, my lord, I have.
You
But
put
these
it-
are not there, what's the point of
No,
replying now?
we'll come
Huh?
to it today. Any reply? No.
No.
Now, my lord,
I-
additional, I need,
Well, this
I,
one,
I have informed my lord. If my lord, suppose their contention, my lord, is suppose now we have total sanction for 107 my lord. Now, if this, our opinion is taken it true, my lord, there will be 54 posts for the promotion, my lord, 53 for the promoting, my lord, in the present situation. Now, if their interpretation, my lord, they, at that point of no vacant post is to be accepted, my lord.
No. See, try to understand.
This is a real court.
Having shown that there were 14 vacancies, right? What he's submitting is, even if there was a vacancy of 14 at that point of time, you cannot be appointed. This is his stand, right?
My lord, appointment order, my lord, is
Showing the vacancy at that point of time since 2008 to 2012 is one thing. Having shown that he's saying that what he submitted is since you were appointed, either on deputation vacancy or the post reserve, I mean, for the direct recruit
my
quota.
lord will have a somewhat cognizance and direct for an investigation into this anomalies.
We'll see. We'll
Because,
determine it.
no, my brother Pangin has started his argument by saying there is something is rotten in the state of Denmark. That phrase particularly is used particularly to denote something has gone wrong. Either the documents obtained by my brother Pangin through RTI through his client. There is something wrong, or else the affidavit filed by the state government is wrong.
We'll determine.
No, that's why. One. Number two, if that is the so,
Yes.
then this comes under a disputed question of fact. Once this is a disputed question of fact, the state affidavit who has come under such oath, section 3 of the Oath Act has to be taken on board first.
Okay.
Now, let's see, kindly come to page 15 of the affidavit in opposition of the government.
Yes. 5 minutes, sir.
Yes,
It's all over.
I'm not taking much.
Enough time.
Kindly see this. Total vacancy period 1/4/2008 to 31/12/2012. 36 posts was there.
Hmm.
And there is no quarrel of the vacancy from 2005 to 2008. So the vacancy has started. Then 2012, when the EPC took place, 8 posts were converted from direct recruitment, and these 8 of them were given promotion. And these direct recruitment was again reverted back to them. They were given this post. Now 36 minus 8 is 28 posts. 28 posts. Now the roster has actually started, the direct and the promoting. Now therefore, 14 posts were there. Kindly come to page 16 for a moment, Miller. It says, considering 50-50 ratio for DR and promotee, that is 14 posts each. Now, my brother Pangin was right, referring to page 117, saying that 22 posts of that file noting. That means 14 plus 8 backlog, 22 posts. That is what the advertisement where he has annexed also, my lord. Kindly see that.
Incorrect.
That is one. Yeah, I am making a going. Lordship decide. That's not a big deal. Now, my lord, kindly come to page 21. 20. My lord, we'll have that annexure 4.
Yes.
Now, my lord, see page 18, my lord. Page 18 of their affidavit. They have said something. I'll take another 2 minutes, my lord. However, it is also admitted fact that they were reinstated, where we were removed on the same day and same day we were given the appointment. They were on the same day from which they were reverted. The reason being there was sufficient number of posts of assistant engineer electric against the promotional quota. Now this cannot be discarded. And this is justified at page, my lord, kindly come to page 47, my lord. Also, the vacancy against which vacancy we were given officiating promotion, my lord. Then we come to 46, my lord. That is DPC note and all. File noting.
36
46, my lord.
of,
46.
of
Affidavit in opposition by the state.
state.
Now, my lord, petitioner number 1, Martho Kamgo, against the year of vacancy 2009 occurred due to deputation of so and so. Now this is with retrospect. My lord will see, kindly see, there was a vacancy for the promotees.
Just see.
And this gentleman has been promoted, my lord. There again,
Why don't you read? Against the year of vacancy to the occurred due to deputation of Sri so and so.
yes, he was
Deputation.
promotee.
Deputation.
He was promotee. He was promotee and he was sent
You
on
read the
deputation.
whole.
Yes, my lord, I have seen that.
You read up to 2009.
Yes, my lord.
Read.
He was sent on deputation and
You
he
are
got
right.
absorbed.
If it is omitted, and the further lines are omitted,
Which
then
line?
you are entitled.
Against the
Place
year of
for-
vacancy occurred due
Against-
to
yeah.
deputation.
Deputation of
So,
so and so,
at the
so and so.
AE so and so or deputy so and so. And
Hmm.
now this vacancy has arisen because Mr. G. Ether has been absorbed in the hydropower department.
When? When?
I know that
Not
gentleman is
2000,
working.
not 2009. So how can you claim from 2009?
No, vacancy has, this is government record, Milan.
That's what I'm saying.
It is not creation of mine.
This is already shown. You have shown. You
Yeah.
have read your appointment. This is as per that only.
My lord, only my request is kindly take this on record.
Yes.
And this kindly see engineer Ruchu against the deputation.
Yes.
Because that was the period when deputation was peak in Arunachal.
Then next.
Then, my lord, kindly see P4, 47, my lord.
Page
Against the page 47.
serial number.
Serial number 4.
Hmm.
Against the year of vacancy 2009 occurred due to promotion of so and so. This is a clear vacancy. Then, my lord, that number 5. This is also the post was very clear. There was a vacancy at that point of time. Against the year of vacancy 2009 occurred due to promotion of Sri so and so Gyati Taka as so and so. The 2 vacancy I could able to demonstrate, my lord. Now again see, kindly come, my lord. Petitioner number 5, against whom he was promoted. Serial number 6, my lord. Kindly see the remark against the year of vacancy 2011 occurred due to promotion of Sri Lijo Mate as EE. Now again, my lord, kindly see. Serial number 7. Against the year of vacancy 2011 occurred due to promotion of so and so. So 1, 2, 3, 4 vacancies. It is palpably visible on the record, my lord. Number 8, my lord, kindly see. Against the year of vacancy 2011 occurred 5 vacancies. Purely for the promotees, my lord. Nothing to do with the direct recruits.
No, 5 now. 5, there are 5 vacancies.
Yes.
then in that case, 5 plus 11. 5 plus 11.
That is what I am
That
claiming.
is 16.
That is what, my lord, we claim.
Then it doesn't tell you with the records.
No, that's
They are saying, government is saying, there are only 14 vacancies. Out of 14 vacancies, 11 have been filled up. I don't know where they have taken away. the
11,
other
my lord, 8, 3 plus, which my brother Pangin was referring to, 3 seats was for us. And then 8 posts meant for the direct recruitees were converted by taking one-time relaxation. So total 11. 11 posts goes. Now that 8 posts has again been given back to the direct recruitee that my lord has seen. So therefore, 28 seat was left, vacancies were there. So it has been divided 50 on the 50-50 basis. 14 plus 8 backlog post, 22 million. So their quota has already been provided to them. That is what it is very explicit in the affidavit, Milord. So therefore, Milord, my contention is simple, Milord. They have admitted they have not reverted my contention and nothing else. And I will have to stand by with this. So that my lord will decide in any case. In view of my lord, my entire submission was structured basically on this page only. Even in the rate petition, when I structured, when I perused the record and I saw that, these kind of vacancies are there, meaning thereby I am entitled, my lord. So therefore, my lord, on the basis of this, lordship's judgment will be there and it covers, my lord. Paragraph 51, 54 is very clear, my lord. So therefore, if there is something, if something has gone wrong in the...
Since you are questioning you have impugned the promotion order on which the basis is the DPC minutes.
because on the
So
basis of
we'll
this,
we'll take
therefore,
into consideration the records of the government, we'll see, not the records of the DPC.
no, the record of DPC, even the private respondent, my lord will see from the file noting, so that everything
Okay.
clears.
I'm rebutting him for 1 second,
Hmm.
because he also argued against it. In fact, your lordship, whole thing is totally misconceived. Nothing tallies. In my lord was pointing on 5 vacancies. If your lordship have this page 46,
No, one thing is clear. Why this page 46 and
46.
7 DPC?
Hmm.
DPC.
Yes.
DPC minus shows
yes,
Yes.
that there is vacancy.
yes, that's what I'm showing.
Huh.
From 1 right up to 17.
Hmm.
How does it tally to the statements?
Hmm.
Obviously, there is something there.
Hmm.
My lord is clear about my submission as regard to the vacancy position, madam. That is only as per records. These are not as per records, these are the volume made. How can it be 17? Page 48, right up to it.
Yes.
You know, 24/7 they held this DPC, where is 8 converted post and the 3 that was given to them were promoted, filled up. Nothing left there.
Which one? Serial number?
Up to 17. Right, say column will say.
Hmm.
Against the year of vacancy 2012 occurred due to promotion of Tariq Mirza SE. How can that be? Sometimes you say 14, this shows 17. And what about the documents given to me under the RTI?
Why some of them have been given retrospective effect?
No, they have not been given. This is the recommendation. Ultimately, it appears that they were not given.
Recommended.
Part of DVDPC mallet, I have only submission mallet. It was turned down by the
Okay,
confidential
this is review DPC.
for DVDPC.
Okay,
Achha.
it has been turned down.
Turned down.
This
This
is
is
not
not
a
under
review
challenge.
DPC on the basis, on which basis you have been promoted.
So this is review
But
DPC.
I could not follow.
What
This
he
is not
said
under-
is, this is the last documents which you have submitted, I mean, shown, relied on. He's saying it's a review DPC, proposed review DPC, which the competent authority has turned down.
My lord, I must
In
point out.
spite
On,
of-
on
in
your,
spite of
on your,
its-
on your representations.
No, in spite of having vacancies.
No, that we
My lord.
cannot. It goes back to you. You say the file noting, unless it is culminated into order, it is much more.
That is simplicity.
So this proposed DPC is not been, is declared by competent authority. Is it so?
These are the proposed review DPC, my lord.
The file
Turned
noting file.
down by the competent authority.
Hmm?
Turned down by
No,
competent.
turning down my representation, my lord, has nothing to do with this DPC. my lord.
Not turning down.
Hey, where is that? Please.
Yes.
Hmm.
Recommended for regulation and retrospective effect from 28 for 2019.
Hmm.
This is the DPC.
Review, my lord will kindly have a look at page number 22, para 11, my lord. We say, my lord, this is proposal for review DPC.
This is a proposal
Yeah,
review
file notice.
DPC.
This is not a DPC, but all along it has been shown as the papers of DPC recommendation.
Hmm.
And this cannot be correct.
I think my lord.
My lord, in terms of
My
the
lord,
judgments, my lord,
my
Heard
lord,
Mr. Titi Tar, learned counsel
my
for
lord,
the petition.
in the meantime, my
And
lord, may kind
Mr.
of pay
Elper
the
May.
various file note in affidavit in opposition.
We'll take care of everything.
Yes, madam. That page 55 to 59.
Hmm.
Something law department
Yes.
has also given.
Yes,
the
noted. Page 55 to 59. Oh, affidavit
55 No, of the affidavit in opposition.
of the
Law
government.
department also
Of
says,
the government.
yes. Law department also, then AR also
Page
says,
55 to 59 of the affidavit.
Retrospective
of the
promotion
state
should be granted.
respondents. Just put it there. For petitioner and Mr. Elper May, learned counsel, standing counsel for the respondent number
2, 3, and 4.
so and so. And Mr. Deepagi, learned counsel for respondent 15
5
to
to 24.
5 to 24. 23 or 24?
24.
24. Hearing concluded, judgment reserved.
Citations I have given.
Lord, a record, my lord.
Keep the record.
This is totally irrelevant, it appears.
We'll see.
My lord, I have to distinguish between the documents relied by the private respondent and the documents relied by the government.
You have to respect.
You
How
have,
can
you
say
have, you
that?
have not filed the affidavit in reply.
Reply, they're reverting that. Come on.
It may hit back
No.
to you.
No, otherwise section 5 of the Official Secrecy Act will become a
Yes,
counting ground for both of them.
Okay.
Has anybody said that
Thank
my
you.
documents are false after hearing this?
No, that is subject
Yes.
matter of this investigation.
Thank you. Yes. No, keep it there, keep it there. We'll proceed with this.
Item number 9 for this.
Yes,
Yes, my lord, I'm for the petitioner.
yeah,
I have to file a rejoinder, my lord. So sometime.
reason that.
Yes,
What reason that? Who has filed the affidavit?
yes, I'm your honor.
You have filed it.
No, I'm for the
Who
respondent.
has filed it?
Well, by-
Yes, I'm the petitioner, my lord.
Who has filed the affidavit? You.
Yes, I have filed affidavit in opposition.
Okay. Mr. So-and-so, learned counsel for the petitioner. Respondent granted 2 weeks. 2 weeks time
2
to
weeks.
file affidavit in reply. Respondent is granted 2 weeks. Miss MS L. Hage learned additional PP and MS J. Doji learned counsel for the
Respondent.
petition.
Respondent.
Respondent.
Respondent number
That's to are present.
Apply for.
Applies me.
Item number 10.
Yes.
Madam, this is a case where the private respondent, though is not a responsible builder, madam, but he has been, madam, the
Where is the rejection order?
rejection is, madam,
It's not rejected. Is it been rejected?
no, not my case has been rejected, and madam,
Let
his
us see
case,
your rejection.
the impugn order is at page number, madam, 31.
Hmm.
Type copy, annexure to madam,
Hmm.
next. Operative is the last third paragraph, madam. Second last paragraph.
Hmm.
The board further verified two remaining firms, namely
You are MS Pagopa
madam,
and Payeng.
Payeng Valley, respondent number 4, madam.
All three, all
Both the
equal.
firm
However,
fulfill
among two firms, MS Payeng showing is recommended by the board based on more experience in previous cases coming as per this submitted. Firm has the story go down and you take the transferring to the other company. In case of draw, what is the condition? It appears that they are equally qualified. When there is a tie, what is the provision? What preference to be given? Where it is? Where is the condition?
that is not given.
Because in case of tie, you'll have to have something. On what basis you
My
have
lord,
done
that
this?
condition you will not find in the terms and conditions of the NIT, my lord.
Not given.
No, it's not given, but it is understood, my lord.
And nowhere, my lord, it is specified that the having more experience will be considered, or my lord, other additional the conditions, the other the qualifications they have added is also not a ground for my lord, the consideration of. My lord,
What according to what is to be done?
my lord, my case is, my lord, not at all.
Suppose both of you are found to be equally qualified.
No, my lord,
One has to be picked up.
respondent number 4 is not at all qualified, my lord. He's a responsive bidder. As per the my
That
lord,
will
documents, my lord,
will not go into all. Sir will not go into all this.
documents the which have been submitted.
Whether it was you are not challenging his qualification. Until the time he picked up on the basis of experience.
Yes, my lord, this is the only my lord, contesting the case that without, though he has not been technically responsive, but his case is being considered. There is no ground as such. There is no specified terms and conditions on which that will be taken into consideration. Why more additional ground? Why other things? Then in such case, we could give much more the experience certificates and additional experience also, my lord. Though there is no such conditions, my lord, only the condition precedent is.
Now forget about the discrepancies of his documents.
My lord.
But in case if there is a tie, if you are equally qualified,
My lord.
as has been held here,
Yes, ma'am. Therefore,
according to what is to be the procedure,
therefore, my lord, my responsive submission is,
it should be tossed.
my lord, since he has already executed the works for last 1 year, the remaining work will be executed. That will be also one way of.
Then you ask Mr. Learned Additional Advocate General, not to the court.
My lord, I have likely saw, Malay, it should be tossed. It should be called like this, Malay. Tell I win and had you lost, Malay. It should be called like that.
So therefore, my lord, technical part.
Who is running the contract? It has been awarded.
Yes.
Awarded.
Okay.
Respondent number 4 is executing the work.
Okay.
Well, in fact, we filed in the several representation before the court authorities in the wrongful manner the selections of the respondent number 4. That was not also considered.
What are the defects which is
Well,
not in
defects-
conformity with the tender conditions?
Defects,
According to you? Of the respondent number 4.
Firstly,
Who is appearing for respondent number 4?
he is not. He is not.
Notice has been served.
Notice served. Additional affidavit filed. To that effect, does the service upon to the respondent number 4
Okay.
was also taken.
Okay.
My lord,
Ah.
firstly, this is a the carriers contractor, carriers contract.
Hmm.
In contract, carriers contract work. The terms and conditions like the furnishing of trucks,
Yes.
vehicles, details vehicle. The vehicles which has been given by the private respondent number 4 is not at all a good carriers vehicle. It is a dumper which is used for the other construction work. So therefore, that extent we have also raised.
Where is the proof that it's not a dumper or something
My lord,
like that?
may I
That
take
is
your
not-
lordship
cannot
to
be used for.
the RTI documents which has been the furnished to my lord, page number 14, annexure 14, page number 48, my lord. Goods carrier, my lord, dumper.
There will be goods carrier, dumper.
Yes, ma'am. And this particular vehicles is also belongs to some other person.
How do you know? This morning I've delivered judgment. Even if a serious allegation of fake documents or false documents cannot be proved unless it is proved by appropriate authority.
Madam.
On just allegation, we cannot, read court cannot enter into all this. Unless you show that you are more eligible and your eligibility has been rejected to the
My lord, putting,
arbitrarily or illegally.
my lord, putting,
Suppose you are eligible, first you have to establish that you are qualified, eligible.
yes.
And then if you are challenging the eligibility and qualification of the others, there must be some proof by the appropriate forum. Just placing a document saying that according to this, that this is a fake document, and unless it is proved, because it will violate the principle of that criminal jurisprudence. Until what you call proven guilty,
Therefore, it was our complaint before the
you are presumed to
authorities
be
concerned.
innocent.
Wrongly, the bids documents of the private respondent has been considered just to avoid the workman. By putting the additional ground, by additional conditions, which has not been at all specified in the NIT, that giving the weightage to the other for giving awarding of the work is also not at all.
Because on the face of it, this court can definitely consider, but then just saying that these are the fake documents, we cannot.
Another, admittedly, this is carriers contractor. That's why we time and again we raised in issues that at least the vehicle has to be the goods carrier vehicle.
It says good carrier. How do you know dumper is not a good?
No,
good
this is
carrier?
therefore this is RTI copy, RTI copy. Which
Because
is,
we're not expert, no. So it says maybe dumper. It says goods carrier. It says dumper.
dumper is
How do we know that it's not a goods carrier?
goods carrier. It is truck basically. Truck.
We're not expertise. We don't know.
It is also
Personal knowledge is something different. Have you seen that? What do we call it? This art mover. We call it JCB.
JCB.
During the flood in Guwahati, it's become a passenger thing. People are traveling on this. So we cannot say that dumper is not a good career.
It is therefore,
Salary.
the technical, the authority, they ought to have scrutiny, and consider.
Yes, what is your
verified
stand?
document.
Malat, the basic difference between the truck and dumper is simple, Malat. In dumper, it's automatically dumps because its system is like that. It does not means that it cannot be a good carrier, Masalah. It can carry, it can carry sand, it can carry bricks, it can carry rice, it can carry, Malat. But it automatically dumps is called dumper. That's the basic difference.
It's more
Yeah.
stronger,
Yes, Malat.
more
Even
security.
more security, more
and,
stronger.
easy,
Yes.
easier,
Easier. It carries more than a truck, my lord.
easy offloading. Yes, these are the views. We cannot say.
Then there are other views, my
That
lord.
is not for the that is not for the purpose of carrying at least
No.
food grains.
No, there is no such any restriction.
No, food for carrying food
See, these
grains.
are the
No.
things. He said there's no restriction.
Just
If
my
it is
lord.
more secure, more stronger, and I mean, easy to offload.
As I
Just now, my lord has said during flood hours in Assam, JCB mother carry the human being. There
It's
doesn't
become
be-
a
yes,
passenger,
become a passenger vehicle.
vehicle
It happens.
at that point of time, at the relevant time.
Yes.
It can be. So these things are very difficult. Heard Mr. M. Kato, learned counsel for the petitioner, and also heard Mr. Aristinabar, learned additional Advocate General for the state. Mr. Kato is granted 2 weeks time to file
A week time will be
affidavit,
granted, my lord.
1 week's time
1 week
to
time.
file affidavit in reply. Less
Right.
after a week. Otherwise, dismiss.
Item number 11.
Well,
Yes.
the petitioner is facing trial before the special judge POCSO Pasigad.
Yes.
In POCSO case number
But
25,
the problem is there's no service report.
they are appearing.
Okay. Are you appearing? Yes. What is to be done?
If they are ready, this can be disposed.
Hmm? Huh? Hmm. Hmm.
Of accession or delay or for the defeating the ends of
Any
justice.
objection you want to file?
No,
So you agree, you have no any objection
no objection.
for allowing this? Will allow the petition.
So my only submission is because that the travesty of the justice, the time constraint is to be taken care of.
Hmm.
And whereas the order, the impugned order is concerned, I don't see any, because I don't see any, nothing wrong in it.
Then
We
you
have
are
challenged the
opposing-
procedural part, Lord, sir.
Yes.
This is just submitted. In that case, let me complete the submission.
Where is the impugned order?
If you order, my lord will find at page number 32.
32.
Accused such and such is present along with learned private defense counsel, Mr. such and such. Learned SPP is also present. Hart learned also. After hearing in length on prospective evidence of DWs, I am inclined to allow DWs mentioned at serial number 4 to 6, 8, and 1 DW from amongst 9 to 11. That prospective list, my lord will find at page number 31.
What is your submission?
My submission, my lord. Even though this trial is being conducted before the special court, but the trial is governed by chapter 18 of the CRPC.
Hmm.
That is trial before a session court. Under chapter 18, section 233 provides that when the accused person is not acquitted under section 231, then he will be given an opportunity to produce his defense and any witness in support thereof.
Hmm.
Unlike recall of witness under section 311, Section 233 gives a statutory right to the accused person. My lord, may kindly have section 233 for a moment.
Yes,
33.
it's before, yes. 233.
33. Very good.
Yes.
Entering upon defense. Where the accused is not acquitted under section 232, he shall be called upon to enter on his defense and adduce any evidence he may have in support thereof. If the accused puts in any statement, the judge shall file it with the record. Subsection 3. If the accused applies for issue of any process for compelling the attendance of any witness or production of any document or thing, the judge shall issue such process unless he considers for reason to be recorded that such application should be refused on the ground that it is made for purpose of vexation or delay or for defeating the ends of justice. In my humble understanding, my lord, the right of the accused to call defense witness under 233 is a statutory right. That right restriction is cast upon by 3 situations provided under subsection. In my respectful service, my lord, the impure order dated 2/2/20.
So according to you, the moment that you file and want to enter in defense by adducing evidence,
My lord,
you cannot be stopped.
stop unless for 3 reasons provided under subsection 3.
Yes.
These 3
There's
reasons,
no reasons has been given.
my lord, these 3 reasons been exempt in this present case. The
Reasons ought to have been given. There's
And-
no reason in the impugn order. By excluding some of
Yes.
them, allowing some of them.
and it is not a case that the petitioner has filed a very long list of prospective witnesses. There were altogether 11 witnesses, including the
11.
11, including the petitioner himself.
Why 11? What are the requirements of 11?
Well,
That's the reason, Lordship.
PW, prosecution witness, how many prosecution witness?
prosecution witnesses.
Lordship, this may be the reason, Lordship, for the Lordship.
You have to reflect.
Lordship, that is
What
there,
has to
Lordship.
reflect?
But there's an
Do
inherent,
you agree?
Lordship, as per this order, Lordship, maybe his applies of judicious mind that he have dropped out that with this may not be that much.
How do
Lordship,
you know? How do the intention and the view of the, unless it is reflected in the
Lordship,
order?
that is there, Lordship.
Tomorrow
Otherwise,
I
Lordship,
may
court has
say so
discretion,
many
Lordship.
things I thought it's within me. Yes.
Lordship, that otherwise the court has discretion under clause 3, Lordship, which is reflected, Lordship, in the clause 3 that for the reasons to be recorded for such applications should be refused on the ground, Lordship, that is made for the purpose of vexation or delay or for the defeating the ends of justice.
In
Maybe,
that case, we'll direct them to consider in terms of the subsection 3 of section 3.
Lordship, and
Is it? Okay.
maybe, Lordship.
Heard, Mr.
Are
So and so learned counsel for the petitioner. We'll give
Lordship, and the thing is that it's already been examined, Lordship. The rest of the defense witnesses, Lordship. Already been examined, Lordship, rest of the defense witnesses.
all of them.
Not all of them, Your Lordship, but accordingly here in the impure order itself, there is a mention that it says that accordingly 7 DWs, including the examined DW 1 and 2. There is a little bit of ambiguity in the orders that I agree, Your Lordship, but then it is already been mentioned that some of them are already examined. So there is no need for furthermore.
Are allowed to. No, what does it say? According 7 DW, including the examined D1 and 2.
Yeah, so 1
are
and 2 are
allowed
already
to
examined.
3, 7 and amongst 9 to 11.
And including the examined DW 1 and 2.
No,
That
one
means
and
DW 1 and 2
one
is
and 2 have already
been examined.
It's okay.
It is not
So,
possible.
and then
Unless the list of prospective witnesses is accepted, there cannot be examination.
According to, they have not been examined.
No.
Huh?
As on today, yes, they have been.
No, it's recorded. Examined When
And
do you
Lordship,
want
this order was passed on 2/2/2024, Lordship. Now we have no idea what stage is this proceeding is now, Lordship.
you take a thing, will pass on 16th.
Lordship.
Next para. Mr. So, huh?
Maybe a record may be called for then, Lordship.
Considering that the impugned order contains page 31.
32.
32. Impugned order dated 02/02/2024 passed by the learned district special judge, huh?
Right.
Special judge Okso Pasigar reflects that well that impugned order that is so considering that the so and so no? Order so and passed by so and so reflects that DW 1 and 2 have been examined, wherein defense witness sought to be examined as DW 3, 7 and 2 have been dropped. The learned additional PP to obtain the latest status, the up-to-date status of the trial of the present case. List on 16/8/2020. We'll dispose it of.
Public.
My lord, although as per the last order, we were directed to file our affidavit within a week. But it seems there is a miscommunication on our part. We have asked them to come and sign and file the affidavit by 20th. So if this, and we have still,
Okay, if you are not in a hurry, it's a public project.
yes, my lord. Today, for our mistake, they had to take the advantage, my lord.
Heard Mr.
H time.
Learned Counsel for the petition. Mr. N. Ratan, Learned Additional Advocate General. As submitted due to miscommunication. Miscommunication or what?
Yes, my lord. We have given them the date of 3 weeks, my lord.
Due to communication gap, the office of the Learned Additional Advocate General has has directed the officer concerned for swearing of affidavit on 20/08/2024.
Furnishing of comments. For furnishing of
Furnishing of
pairwise comments.
various comment on or before 20/08/2024. Therefore, he submits that further 2 weeks time may be granted for filing affidavit. Praise the Lord.
Interim order may be continued.
This after 2 weeks,
After 2 weeks.
interim order, then yes, will continue.
Obliged.
Your Lordship,
Yes.
Your Lordship, the previous case, 16 would not be pregnant. Okay, there, I will be out of it, Your Lordship. If it is on 26 or 27, that would have been.
So we'll pass the list it tomorrow.
Tomorrow.
We'll dispute it.
Yes, tomorrow, Lordship. Okay, I'll try to, Lordship, get the instruction, Lordship. Lordship. Okay, okay, Lordship.
Tomorrow is fine.
Okay.
Anyway, what do we want? Where is the petitioner? What do we want?
27 or 28?
Give it 27. Otherwise, also 16 is post Independence Day. Yes.
My lord, the service upon respondent number 2
Is return unserved.
Okay, what is to be done?
Your lordship can appoint a
Legal aid counsel.
Your lordship.
Return unserved.
Yes, because address that was given, they are not found here.
Can you not, can you not take steps?
Your lordship, it seems that the person,
You are amicus.
Jail.
Will direct the institute to take steps.
yes, that can be done. Otherwise, also this matter is ready for. We have also got the paperwork. If your
At
lordship,
least after 4 weeks or 4 weeks, so that we'll fix it for hearing.
yes,
Not Mr. H. Lampu, then amicus curiae and MS TG London and this before this thing. The matter is otherwise ready for hearing, except the service of notice upon respond number 2. List of it is notice that the answer notice has been received by Mr. The registry to said issue notice for service of notice upon the respond number 2. The matter be listed for hearing in its usual course. List after 4 weeks.
All right.
Award service report in respect of respond number 2. First. Not be able to take up the hearing. Award service report. Award service report, in that case, award service list after 3 weeks. 2 weeks, 3 weeks making.
Chief, I am for the respondent in IA.
Yes,
So I may be given 1 week time, your lordship. I will file my
objection yet to be filed. You have taken them, yes. IA is for what?
for delay. Condonation of delay.
Heard Mr. Bijamal London Council for the applicant. Mr. Ekesing London Council enters appearance on behalf of
1 for respondent number 1, your lordship.
for respondent number opposite party respondent number 1. He pressed and pressed for 2 weeks. 2 weeks time to
Let's say
file
1 week
objection to
before.
the IA. Praise the Lord, list after 2 weeks.
Lordship, this may be recorded respondent number 2 and 3 also appear because we have taken justice service again on last of respondent number 2 and 3.
2 and 3.
Yes,
2 and 3. Mr. So-and-so appears for respondent. You are not filing anything.
No.
Mhm.
Item number 17.
Yes.
your lordship,
May I
service incomplete, lordship.
Your Lordship, since the service upon respondents are still awaited, Your Lordship, and the service is awaited since very long time. It's been
Take
more than
precedent.
4 months. Your
Or
Lordship,
Mr. So-and-so learn counsel for the petitioner.
if may,
Petitioner to take steps for service of the petitioners
Lordship,
to take press steps for service of notice upon respondent number 2 to 16.
2 to
Your Lordship,
26,
if
lordship.
I may be allowed to take by alternate method, Your Lordship, by jurisdictional police station, Your Lordship. Service may be taken for jurisdictional police station, Your Lordship.
By alternate mode, whatever.
By alternate mode. Oblige, Your Lordship.
Right.
Yes.
Already step has been taken. So
There is no office note. Mr. Okay, office note dated Mr. T. Torup, Land Council for the petition. Office note dated 12/8/2024 reflects that
I may be allowed to.
service report respondent to 1 and 2 is yet to be received back. The you undertake Dusty.
With Dusty service, I may be allowed to Dusty.
Mr. T. Torup, Land Council is permitted to take steps by Dusty mode. No appeals for the petitioner on call. Appellant on call. It is as per the office note dated 12/08/2024. The Learned Council has not taken steps. Another in view of further 1 week time is granted to the Learned Council for the appellant to take steps, at least after 4 weeks.
I think we will ready.
Service has not completed, lawsuit.
So it's
For respondent.
non appears more than so and so appears. Ever submit at least after 3 weeks.
Apply for.
I think we will ready one.
Respondent number 2 and 3.
No, I'm body state, your lordship.
Respondent.
Private respondent, your lordship. 2 and 3, your lordship. Private respondent, the informant.
Time also nobody appears.
If they can, they have taken time for filing affidavit in opposition, perhaps, your lordship.
No, last time nobody. And non appears for the petitioner in call. Service is complete. List for admission after 2 weeks.
After, your lordship, 3 weeks.
2 weeks.
2 weeks, okay, obligation.
My lord, this is a joint petition, my lord, for quashing of the proceeding pending before the learned CGM, Rapuja, my lord.
List
Therefore,
for admission hearing. Administered this of the Learned Council for the petitioner, also MS Swenson. Scanned copy of the trial court records is received. List for admission hearing after 2 weeks.
3 weeks, my lord.
2 weeks or 1 week?
3 weeks, my lord.
3 weeks.
That interim order is there, my lord.
Interim order process will still continue.
Obligation.
On previous occasion, may I please lordship, the Lord Council for the Government has directed to produce the original copy also of the document.
Lordship, we need some time to file affidavit, your lordship. Bring on.
Bring the original copies.
Yes,
your
lordship.
Why this IA?
This is for calling of the original documents from the respondent of the
Okay.
petition. These 4 documents, lordship, they furnish me the photocopy, but the original copies are with them.
Yes. So
We need time, your lordship, to file affidavit.
they are yet to obtain
Yes,
the
Lord.
original.
Yes.
And Mr. K. Learned Council for the applicant must MSR Basar Learned State Council. Respondent is granted. Further 3 weeks time to file. File affidavit in terms of the order dated 24/6/2024. List after 3 weeks.
Deeply obliged.
Item number 25. 23 and 25.
May I please, Your Lordship?
Yes, sir.
Lordship, this IA may be disposed of today.
Yes. IA is for what?
IA is for withdrawing of the uncorrected form of affidavit filed by the filing staff, Your Lordship,
Okay.
due to. And in the last order, Your Lordship, the petitioner counsel was ordered for filing of objection,
Yes.
if any, by showing under what provision this IA is not maintainable.
Yes. Have you filed?
Yes, madam.
Where it is?
Objection I have filed.
What
Yes,
provision?
he has filed, Your Lordship, and no provision, but
Should file in is not on record. Registered to verify and take this. Yes.
he has reflected my name in every paragraph, Your Lordship.
Your name?
Yes,
P. Sangeeta?
yes,
Yes. Why?
as a standing government advocate.
What is your objection?
My lord, in this case, the case was initiated in the month of September 2022. And from the since then, as many as 15 times.
I direct you to
Where in the IA?
indicate which provision you are
Yes,
objecting.
my lord, I'm coming to that point. I'm coming to that point. And then after returning just for filing affidavit in opposition for more than 15 times, again they are seeking for withdrawal of the same, which is almost 2 years has been completed now.
Suppose
No,
if it is withdrawn, what prejudice will cause to you? Is there anything that they cannot, change their stand?
My lord,
Which will prejudice you?
my lord, firstly, usually when affidavit or petition is being filed, certain amendment is always done if required be by the petitioner, or same is the case with the
This
government
can be
extending
withdrawn
counsel.
also. Any petition
So
can be withdrawn. Any application can also be withdrawn.
IA,
On the author, if the author makes a prayer, we can allow them to withdraw.
No, after filing affidavit of opposition, that cannot be withdrawn easily.
Which is under which law?
Usually it is the
Not
withdrawal.
usually, we want the law, the provision.
My lord, basically,
Heard, Mr. Is this
My lord-
MS P.
My-
Sangeeta, learned counsel for the learned state council for the applicant. By filing this introductory application, the applicant has sought for where it is. Okay. This is the objection. IA is where? Huh? This is the IA. Okay. What is the ground of your withdrawal?
due to inadvertent overlook by the filing staff, Your Lordship, an uncorrected form of affidavit has been filed.
Filing this application, internal application for withdrawal of the affidavit in opposition filed by the state on the ground that same contains
The language is,
certain
Your Lordship,
certain
incomprehensible.
errors
Language
due-
itself is incomprehensible. Your
due
Lordship.
to inadvertent mistake on the part of the filing staffs. Mr. M. Nebo, learned counsel for the opposite party petitioner.
Yes,
Your
madam.
petitioner.
Yes, madam.
Well, vehemently objecting to the withdrawal. Submits that once the affidavit is shown and filed before the court, same cannot be allowed to be withdrawn. Mr. However, on pointed query, the learned counsel, Mr. M. Nebo, could not point out under what provision of law the same can be. The same is not permissible.
But once it is.
And also not able to show if the affidavit of opposition filed by the state is withdrawn and to file a for filing of proper affidavit responding to the stand taken by the petitioner. That what is that? Yes. What is the last one? Who is allowed to be withdrawn for filing of the proper response to the stand taken by the opposite party of the great petitioner. What prejudice would cause to the petitioner? Before that, MSP after that, first paragraph. MSP Sangeeta, Learned District Council, submits that the affidavit, since the affidavit in opposition has been filed inadvertently with certain errors due to the filing step of the state respondents. The state would like to file a proper response for would be filing a fresh affidavit for proper determination of the issue raised by the petitioner. What is the issue? She submits that no prejudice will cause to the petitioner. Therefore, she prays that the additional affidavit in opposition filed by state may be allowed to withdraw. And then you record the submission of that. Huh? Yes. What is the issue you have raised
in the petition? We have challenged the order passed by the Deputy Commissioner, wherein eviction order was passed against the petitioner. And
very simple issue. Next paragraph. Having considered the submissions of the learned counsel for the parties and also considering the nature of the issue involved in the writ proceeding, in the present writ proceedings, as well as considering the affidavit in the opposition filed by the petitioner, there appears to have contained certain error which seems to be inadvertent error. And no prejudice would be caused to the petitioner in allowing the state to file the first affidavit in the opposition. The interlink application is allowed. Not allowed. I deem it appropriate to allow the applicant to withdraw the affidavit in opposition filed by the state. In the interest of justice, police staff. Accordingly, the IA is still allowed to dispose the.
But since it has been delayed for 2 years, so the specific time period may be given for filing affidavit. Otherwise, it will be in the same manner. It will be
In main immediate petition, the heard Mr. Swain, the MSP Sangeeta Learned State Council is granted further 1 week, 2 weeks, 1 week time to file affidavit in view of the vehement submission of Mr. M. Nibo for early filing of affidavit of opposition, as the matter is stated to be pending since last 2 years. Have you seen there are 2012 matters also?
only
List after a week.
obligement.
Item number 26.
Today we have filed our affidavit.
You have filed?
Yes, Your Lordship, today.
Okay. Though the office note that is 12/8/2024 reflects that affidavit of opposition is yet to be filed, MS Arbasal London State Council submits says she has filed the affidavit in opposition this morning. Have you received it?
Yes, sir.
Mr. Lona, D. Lona,
Dilona.
and counsel to the petitioner. Submits that he has received a copy, Mr. accordingly. No, Mr. You are for? You have also received.
Yes.
You are for respondent number? 6. 6 is what?
Private response.
Private.
You are?
I'm for the
You are
petitioner.
petition, okay. Mr. So-and-so for respondent number 6. You are not filing.
We have already filed.
You have already filed. List better after 2 weeks.
2 weeks. Obligement.
No, hearing, continue. We have time. You call the hearing. 28. 27 and 28.
Your Lordship, last time your Lordship instructed me to bring this written instruction, my Lord. My Lord, regarding this, we had a meeting yesterday also. I also personally attended there. But unfortunately, in this case, we are not in position to come up with written instruction, my Lord, because no record is with us regarding this, number one. But as per their personal knowledge, my Lord, as per their personal knowledge, this appointment was marred by this corruption. It was one of the most sensational case for job scam that erupted in Arunachal Pradesh, and even the SIC has said to we have search-sheeted the issue, my Lord, and even the appointing authority was arrested. It was there, not from record, but it was informed to us by them from their personal knowledge, my Lord. And thirdly, my Lord, still, my Lord, all this no sanction post has been placed to us, even to the IMC, Itanagar Municipal Corporation, my Lord, still no such this sanction post came. We admit, my Lord, this was a matter of this 2018 Municipal Council, my Lord, not connected to us. But since we have taken over this their jurisdiction, my Lord, so we came into role, my Lord. But position is, my Lord, we are not in this position to give anything on record, my Lord, because record is not with us. But that's why, my Lord, for that, my Lord, we will have to rely on the affidavit filed by the government, my Lord. Government has filed the affidavit in both the cases, and this is the situation, my Lord.
Yes.
My Lord, if there is any SIC case against me, then my Lord, I think if later on, it may be happen, my lord, I'm acquitted. And at that moment, my lord,
See,
it
we're
is-
not concerned about the criminality because your appointment is reverse the rule. Nothing except for some advertisement. Was there any advertisement?
advertisement is there, walk-in interview advertisement
Walk-in
is there, and
interview.
I have appeared.
Under what provision you have been appointed? What is the rule?
My lord,
What rule has been followed?
my
That
lord,
too regular appointment.
it's a.
Is it a
ad hoc-
contingency,
ad hoc
something like that?
contingency.
Contingency.
Ad hoc, I think.
Either way,
same-
if it is a contingency, you have no right. If it is a regular post, you also don't, equally that in that case also you don't have a right to, because it's not in accordance with the rule.
If there is no sanction post,
Not only sanction was recruitment process, no proper recruitment process.
process, walk-in interview, advertisement is there, and the interview was conducted.
Writ
And
petition
I have
dis-
appeared,
writ
and
petition
I have
dismissed.
selected.
Sorry. This hard, Mister. You want to try somewhere else?
No, no. All right.
Or to go council for this item, 27 and 28. Both the learned counsel for the petitioners. In both the cases.
Yes.
Also had MS P. Pangu, learned counsel for. Learned state council. For respondent number
1 in 3, Your Lordship.
1 and 3. Mr. T. Jamo.
Our name has not been reflected, my lord.
In the,
So,
with that, Mr. T. Jamo, learned counsel. Sending council for the Itanagar Municipal Corporation. We'll just say that. Hmm. In writ petition, you just read. In writ petition 525 IP of 2018, the petitioners had challenged the impugn orders dated 25/06/2018 and 27/06/2018. Whereby and also dated 10/08/2018, but by which orders the petitioners, the service of the petitioners as LDC have been terminated. List of in writ petition, next page. In writ petition, same order, services as municipal junior engineer, post will be different, have been terminated. Well dictated. Dismissed.
Yes.
Order will follow.
Item number 29. May I?
Yes,
I'm on behalf of leading counsel. Would like to adjourn this matter.
you would like to adjourn.
Yes.
You adjourn it. Let him adjourn.
The matter will fix for 20 of this month.
And Mr. Strange, learned counsel for the petition. Learned counsel appearing on behalf of Mr.
Arson, leading counsel.
Petitioner. Arsona.
Yes, my lord.
Arsona. Not heard, Mr. So-and-so, learned counsel appearing on behalf of Mr. Arsona, learned counsel for the petitioner. List this phrase for adjournment of the matter. List of phrase allowed. List this matter up on 2008-2024. Mr. T at the learned additional PP and
K4C.
K4C.
For respondent number 2 and 3.
For respondent number 2 have raised no objection and are present.
Of life.
She'll take another 2 days. Will you take another 2 days?
So even if I may start now also, it will not finish today.
Tomorrow? Day after?
Anytime.
Some other day. Or Mr. Empathy, learned counsel. Learned senior counsel assisted by Mr. Empathy, junior learned counsel for the appellant. Due to and MS TG learned additional PP. You are also appearing.
I am for the victim, yes, that's what I'm doing.
And Mr. B Pitcher for respondent, learned counsel for respondent. Next parent. Due to paucity of time, matter could not be heard. Matter could not be taken up. List after 2 weeks, 1 week.
Any day.
1 week.
Any day.
Yes. You are always ready.
Ready.
Ever ready. Yes.
Item number 33.
Be able to finish.
My lord is having BC at 4:30.
Can you finish it?
I'll take some time because there is a question of law whether the deputy commissioner has a power to decide title in exercise of power under Land Acquisition Act.
On the face of it, not at all.
Yes,
Cannot.
that is my case.
How can they decide the title?
He cannot. Wrongly decided and wrongly given the
If-
compensation money to somebody
If
else.
it is a true facts, which you are projecting.
But that is a fact, my lord.
Yes,
Well, there's Kaba and all those things.
yes. We'll continue.
We can start.
30 minutes we have. Nay, 20 minutes.
He will
Can
take,
you finish it? How long you will take? How long you will take?
I'll take only 5-6 minutes.
You?
I will have to place the facts. placing facts will always take 10 to 15 minutes.
You will start by you. make
Or
it
my lord,
tomorrow.
no, or my lord, can it be because I have this long tour, my lord, out of country. So then I have lot of activities to do. I request my brother also to
What is
accommodate
there?
me.
What facts are? I mean, how long it will take?
I'll take
Much time. Facts you don't have to.
No, because I have
I've read the facts. You submit on the law.
That's why, my lord, still then this has to be relied.
Facts, I'll tell you. I'll tell you the facts.
Please, my lord.
You are claiming the land. You said it is an ancestral property which has been given to as your a share after the Keba in 1988, right? And during the assessment of the land, the respondent has claimed that 175 square meters, which is in your possession on the basis of the Keba 1990, right? And the ADC has made a payment to the respondent 40,000 rupees, right? You filed an appeal you approached up to this court, right? Was sent it back. Have you approached this court? No. Anyway, you filed an appeal against the decision of the ADC.
Correct.
And the DC has affirmed the decision of the ADC.
That is
Therefore,
where
you are here.
That is where
Now, how the appeal will lie against the judgment of the order of the ADC? Number one. So, since you have approached the wrong forum,
and then there's limitation thing was done away.
This decision of the DC may not have, it may be void. It's a nullity. It doesn't have the jurisdiction, right? Then in that case, you have to challenge the ADC's order, which you have not done in this petition.
No, basically, my lord, he has affirmed it.
Yes.
He has affirmed. So while affirming that, due process was not followed. Only simply.
What is she?
Page 58. Annexure 12.
05-010-2017 passed by the Deputy Commissioner, allow with uphold the ADC Kamba without jurisdiction. So your challenge is 05-10-2017. You have not challenged the decision of the ADC Kamba.
No. If the basis of affirming by the Deputy Commissioner is interfered with by my lord, then I will have my own remedies. That is one window that I will have. Because at least you have not given me the opportunity to adduce evidence nor cross-examination. That due process was
No,
not.
therefore, in that case, will not interfere with the. If you have, are you saying that the DC has no jurisdiction?
I am saying that under this land acquisition provision, Deputy Commissioner has no power, even the ADs. That one case.
No. Who has to decide?
It is the Deputy Commissioner under section.
Is it a collector as a court?
No. When there is
is it a quasi-judicial proceeding or judicial?
No, quasi-judicial. Any proceeding under the Land Acquisition Act for determination of the rights and then the mode of compensation. So then what happens when there is a dispute between the parties? It is the ADC, it is the Deputy Commissioner who acts. ADC is not mentioned even in the provision. It is the DC who will decide. And in the base case, we'll
Who has approached ADC? Who has approached ADC?
It is ADC who has issued
Forget about it. Who has approached ADC? It's you. Who has approached Deputy Commissioner? It's you.
That's why, that was a wrong thing. The series
So
of
if he
litigations.
doesn't have the jurisdiction, it's a nullity.
But then it has to be
So
kept through the
DC,
judicial process.
no, we'll may see. We may say the order passed by the DC is a nullity because it doesn't have the jurisdiction. Not because he doesn't have the jurisdiction to decide the title. That's because no appeal would lie against the decision of the ADC.
Correct.
In that case. But the decision of the ADC remains, which you have not put to challenge here.
That is, they should have done.
So my prime facie view is, will set as the Deputy Commissioner order, saying that it's a nullity because he doesn't have his jurisdiction, because no appeal lies against that.
Correct.
But it may go, but then the decision of the ADU will remain, will not touch that, because it's not challenge here. Right?
Only then that.
What do you say?
Yes, my lord.
And will provide a liberty. Whoever is in terms of if permissible under the law, anyone can approach.
I'll raise only 2 points, my lord, regarding mentally ill. My lord, first, my lord, the whole basis of claiming disputed land is cover of 1988. That was held, not convened on 1988 by this honorable court in miscellaneous first appeal of 1 of 2001, my lord. It's in my affidavit in opposition, my lord, at annexure 2, my lord, page number that.
No. Before going into all these details, what I am proposing, my prime facie view is, the Deputy Commissioner has no jurisdiction. And is not an appellate authority against the ADC. So therefore, any order passed by the court or authority having no jurisdiction is nullity, right? So we'll set aside this. It need not be set aside also. We'll observe that it's a nullity. We'll say nullity.
That will also.
Now we'll allow all of you, both the parties, to approach
appropriate for.
Appropriate, provided it is,
I think that
as may be permissible.
My lord,
under
in
the law.
that case, my lord, I want to clarify one thing, my lord.
No, what do you do?
My lord, land was acquired under Zoom Land Act, my lord.
No, in that case, we'll have to hear it. This is a jurisdiction now. We don't have to go into the merit. If you agree to that, suppose in that case, I think it's in your favor, though. I mean, he's being basically agreed by the ADC.
Yes, madam.
Affirmed by the ADC, but technically he has not challenged the ADC's order. Right? So we'll held that it's the nullity. This is order. Remains. ADC order remains in your favor. But we'll make an observation that the liberty to the parties to approach the appropriate forum as may be permissible under the law. So tomorrow, obviously you will not approach, he will approach.
Liberty, my lord, first, my lord, after second appeal was.
No, that's what I'm saying. Liberty as may be permissible under the law. If the law doesn't permit.
That at least that liberty to approach, that's all.
So otherwise, if you want to contest, I mean, this is my because ultimately this has to be the order.
There is no point.
But if you are not satisfied,
there is one
we'll hear you on merit, we'll enter into, I mean, look into the papers. But ultimately, in a revision, what can we do more?
I argued before Lordship TJ Saikya.
So we'll take it up tomorrow. On this tentative thing, tentative view, we'll dispose it of. Because you are agreeing to it.
No, I think that part I agree. I will not enter it.
You come and you also think about it. Ultimately, we'll have to give the liberty. But prima facie, DC doesn't have the jurisdiction. Of course, it's his fault.
No, your ADC order is surviving. So whether they will, Malad, on that count, I think we are unanimity, Malad.
Yes, well, listing it tomorrow. We'll
Well,
pass the,
no,
no, I have so many orders to pass. We'll pass it tomorrow in the open court.
No, my lord, I don't have anything to argue tomorrow because that.
But we'll be listing it. You be here. All
Well,
right.
Kindly relieve me sometimes also because whole day sitting. Well, but my lord, I
List
concede.
matters. List this matter for orders tomorrow. We'll dispose it of tomorrow in a simple way. We'll not go into all this.
You know, my younger will be there. I'll not,
Whatever.
who's CRPC?
Yes.
Huh?
Yes.
Item number 1 and 2.
Is there?
Petitioner is not there. Sunil Mouse.
Not appears to the petitioner. After mentioning it for adjournment for so and so. Listed better tomorrow. That's all.